Good afternoon, all. This directions hearing is in the matter of CFI 070-2022 and is being held by way of video conferencing before His Excellency Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by KBH Limited. Lead counsel is Mr. Richard Hill, KC. The first and second defendants are represented by Davidson and Co. Lead counsel is Mr. Andrew Trotter. The third defendant is represented by Altamimi and Company. Lead counsel is Mr. Adam Baradon, KC. Thank you, Your Honor.
Yes, good morning, all of you. So I'm just trying to get those cameras. There's quite a lot of points to go through, some of which can be dealt with very quickly, I think. Should we start with the position of the third defendant in respect of acknowledgement of service? Mr. Baradon, are you planning to acknowledge service?
I had an answer for you. We received the reasons from the Court of Appeal only about an hour and a half ago, and those require to be reviewed before I can say yes or no. That doesn't prevent Your Honour from making an order as to by when we have to do so, but we will have to consider that.
If I made an order under, was it 12.82, I think, that the time for filing an acknowledgement of service be fixed at, 4 p.m. on Monday?
Your Honour, thank you. 4
p.m. on Monday, do you?
More time would help, but I'm not going to push hard on it.
It'll give you. It doesn't. It's a formal document. It doesn't have to be expanded, and you should have had the opportunity of reading the reasons by then.
Yes, thank you.
And forming whatever view. So, Reem, can you make a note of make sure that all these points are incorporated in a final order that's drawn up after this hearing?
Certainly, Your Honour.
And perhaps parties can help my court officer making sure we don't miss any points. Right, the second point, I think, is the third defendant defence. I've seen very briefly this morning a skeleton argument from you, Mr. Baradon. And what do you want to say about this?
Your Honour, the position as summarised in the skeleton argument is this. The chronology is obviously quite extensive, but the court is more than familiar with it, so I don't propose to go through it in any real detail. The fundamental issue from D3's perspective, and I invite the court to take the same view, is that as things stand, with skeleton arguments due in 12 days, a trial in 2 weeks, and all the other things that go with that, it is not possible for my client to be fairly represented at trial, to say nothing of the defence. And so at least the following provisions of the overriding objective are engaged: the principle of equal footing at subparagraph 1, at subparagraph 3, proportionality, especially as to the amount of money involved. Your Honour knows that the claims for $100 million and penalties from my client in his personal capacity. B, the importance of the case. The allegations made against my client are of the most serious nature. They're of fraud. And that's obviously of great importance both to him as a matter of principle and his reputation. And C, the complexity of the issues, which I will come back to. Against that, one has to balance in subparagraph 4 of paragraph 1.6 of rule 1.6, the question of expedition as against fairness. And the point on fairness is the one that's made in the skeleton argument. Whatever representation has previously been had, my client lost all of his lawyers, not at his own election, but at theirs, and that's been put in the letter to the court. That necessitates the instruction of a new team. The new team has had various disruptions, not least the permission to appeal process, which has only concluded today. But also, as Your Honour will have seen, we only got access to the bundle yesterday afternoon. Now, parking all the other issues we've had, all the other work streams and securing funding and so forth, that means that I can't see what's on the file, what the evidence is, what the disclosure is, or even what the pleadings are. I've seen some of it. With the existence of a confidentiality order, I wasn't even entitled to see all of it. That is deeply problematic, just alone with the skeleton in 12 days, let alone the defence. I observe also, and I've made the point in the note, that when one looks at the position of the third defendant in the proceedings and how the third defendant is to plead, the court will expect at any point in proceedings, but certainly this close to trial, that the third defendant's pleading is cognizant of what has been to date. And by that I mean the procedural developments, the requests and answers on document production, what has actually been produced, what has actually been pleaded, including by way of RFIs, and the expert evidence. It would be very difficult for a pleader to sign and advise their client to sign a statement of truth on a pleading that was purely responsive on the face of the claimant's pleading. That goes all the more in this case because despite the suggestion in Mr. Hill's skeleton argument that essentially my client is tail end Charlie and need only plead to 3 very specific points, the reality is my client has been joined as a party and is entitled to and will wish to engage on the full gamut of the allegations in the claim, but also in that respect, because his position differs absolutely diametrically and centrally on the key issue of the validity of the various written documents from that of D1 and D2. So he has a real conflict of position as against D1 and D2 and simply can't just adopt, and the pleader can't just adopt their position.
But can I interrupt you for a moment?
Yes, please.
Let's, taking that at face value, that's been the position since July or thereabouts, when he was joined an application he wasn't present at, but he knew about because he then did the requisite steps in order to be able to challenge jurisdiction. What steps have been taken to between then and now to put himself in a position to deal with these matters?
Well, firstly, I should say I can make no waiver of privilege, but secondly, I'm not instructed by Davidson. I'm not part of the old legal team, so I simply don't know. What I do know is that the new team has been instructed and come on the record, I think it was the 25th of September, albeit subject to the issues to which I've alluded. But a reasonable litigant in a position where they're faced with a joinder application, which evidently from the fact of the application made to set aside, they thought there was a good prospect would go away. And the same is true from the fact of permission to appeal. And indeed, the reasons, insofar as I skimmed them today, seem to acknowledge that there is some merit in some of the points of law, at least taken on the permission to appeal. So a reasonable litigant faced with all that situation shouldn't be required, nay, expected by reason of the directions that are made, to incur the duplication of endeavour, the cost, the time commitment, and so forth, of instructing a shadow legal team, those costs being entirely unrecoverable, one would expect, if he were to fail on if he were to succeed on the set-aside application. So the starting gun in my submission is the determination of the permission to appeal application.
The problem with that is it ignores the time that was allowed to lapse between July, I can't remember, June or July, between the order for joinder and the challenge to jurisdiction, which was quite a considerable period at his own volition.
As I say, I wasn't instructed in that period. I can only say that the fact that an application was made suggests that that's where the endeavours were focused. I expect, but I have no knowledge, that the legal representatives for the company defendants were also tied up with the other procedural steps that appear to have been taking place over that period. But I can't say more about that. The other element in terms of chronology, which in my submission is material if Your Honour is against me on my primary submission, is that all of the timing of this falls out from a very, very belated decision by the claimant to join the third defendant. So I acknowledge, and it will weigh heavily on the court, and rightly so, that this claim has been up and running in principle for 3 years, but the joinder application wasn't made until more than 2.5 years into that process, and indeed after both of the original listed dates for the trial. The original date, I think, was February, and then it was adjourned to March. So this is something that the claimant has inserted very late in the day, and it would, in my submission, be quite unfair to count against the third defendant any delay that, despite my submissions, Your Honour is inclined to find between the jurisdiction order and the resolution of its challenge, but not the fact that the claimant has brought this as essentially an ex post facto claim after the date of the original trial. The resolution of this, which which my instructing solicitors have proposed, in order not to introduce further undue delay to the process, is a rather whip-crack procedural timetable to a very slightly adjourned trial. Your Honour, in all of those submissions, what I haven't addressed, and what is, of course, of central importance, are the issues that arise from the claimant's pleadings and disclosure, which would have to be addressed in any event for an orderly trial. Would it assist for me to address those briefly?
Address them briefly, yeah.
And I should make one other observation, which is that the service of the jurisdiction order in late July coincided with traditional holiday periods over the summer, which may have introduced some delay, but I can't say more than that. The issue on disclosure is this, and please forgive me as I work my way into working out quite what's going on, but there is a summary of the position in the jurisdiction skeleton argument, and if I could ask the EPE to put up bundle G, tab 66, page 5, please. I'm going to go to the bottom to the B2 heading. If we can see that in the next page, paragraphs 12 to 14.
Yeah.
So the issue, as I understand it, is this. A question has been raised, and Your Honour has rightly found that this is a point and issue that will be tried on the limitation defence. The question is as to when Mr. Kahlon, the claimant, came to certain realizations in relation to a mistake. Now, as I parse the pleadings, that arose initially as a fairly tangential technical point on the question of law of mistake and avoidance of a contract for mistake in the dispute as between the claimant and the company defendants. It was, if there's a list of issues, I don't believe there is one. I looked in the bundle, I couldn't find one, but you'd expect it to be quite far down the way of the list. That issue now rears its head as an absolutely central point on a complete defence, which is the limitation defence. So it has a completely different prominence as regards my client to that which it had previously in the litigation. So it merits additional scrutiny. What additional scrutiny yields is two things. The first is that such document production as has been given has been made by reference to the wrong period. So in the reply, and I can give Your Honour the references if it's helpful, but if I can describe it first. Yeah. In the reply, the claimant pleads a date of knowledge which is in or about August 2020. And the searches that have been conducted have followed from that pleading. In his trial evidence, the claimant has suggested that his knowledge arose at a totally different period, essentially when he was preparing this claim. And that is something which doesn't appear ever to have been given any detail as to what the relevant period is. But in correspondence, and perhaps I should show you this, it's EPE Please, Bundle K, page 976. This is KBH's third letter of the 9th of September. I think we are over the page. There is a suggestion in this, if we could go over the page again, please. What I'll do, I'll find the page reference and I'll give it to you, but there it is at the bottom. You see paragraph 15, the reference to in or around August 2020. And you see that the search that was conducted for documents followed from that understanding. But could we just go over the page, please? The claimant, if we could get to the top of the page. The claimant has subsequently said that the discovery of the issue appears to be on or around 30 April 2022. Sorry, I've got the page wrong. If we could go back one page, but it's in the bottom paragraphs. So where we get to is the claimant's searches are premised on the wrong date. They're premised on October 2022 rather than April 2022. And that then manifests, if EP could please open up Bundle F, tab 7, page 12. That manifests in the searches that have been conducted. So in the middle of the page, this is the disclosure, the document production searches that the claimant has produced, I understand, after being ordered to redo the disclosure exercise. If we could zoom in the middle of the page, DPO category P3E, please. It will be immediately apparent to you, Your Honour, that the search term for P3E, that's the relevant search as I understand it, is from 1 June 2020. So the search is conducted, not from April, when Mr. Kahlon's third witness statement says he discovered the issue, but instead from some time quite subsequent. And if Your Honour recalls, Your Honour's order said he should be searching for a couple of weeks after the date of discovery. So he's missed that period in his search. That is a fundamental point of fairness given the centrality of the defence, the limitation defence, because there has been no search for the documents that would substantiate the defence. Now, I understand that there's been some debate previously upon whom the burden lies to establish the limitation defence, whether it's the claimant or whether it's the defendant. It doesn't really matter here, because if the claimant's got to prove his case, we need to see the documents so that I can test it. And if my client has to prove the case as to the date of discovery, well, I need to see the documents in order to do that. So either way, we need to see the documents and we need the search to cover the right period. Whilst we're on this page, I note also the search terms mistake, accident, realise. And I observe, and this may not have been a point that was pressed previously because the point was less central previously, but I observe that those are not the types of terms you would expect to crop up in the type of communication for which we're looking, a communication in which Mr. Kahlon realises the issue, which he now claims is an issue, and may have had communications with friends, family, whoever it may be, with himself, is not obviously likely to be written in terms that lawyers might plead or have been pleaded. And so we would be searching rather more stringently, given the short time frame. We would rather have a much more in-depth search to produce documents. I've taken that at a fair canter. Does it help to
Yeah.
unpack any of it, Your Honour? If I show you the relevant passage in your judgment on the jurisdiction application to see the relevance,
Yeah.
perhaps that. So if we could open up, please, EP Bundle C, tab 35, page 11. And if we could zoom on paragraph 34, just paragraph 34, thank you. And if I could invite you to read that, Your Honour.
Yeah. Yeah.
Would it assist if I show you the pleadings?
Well, you've got to tell me whether it would assist.
Well, I've summarised their effect. It's that there is this tension between the reply and then what comes in the trial witness statement. There's that tension essentially, and the trial witness statement doesn't commit, despite saying that he discovered things while he's starting to prepare his claim. Why don't I show you that? So let me show you the reply very quickly. It's bundle A. I have perhaps the wrong version of the reply, but it doesn't matter. Tab 4.1, page 4. And at paragraph 10, the final sentence of paragraph 10, Your Honour, is in or about August 2020, and that's the basis on which the search has been conducted, as we saw from KBH's letter. Whereas the trial witness statement is bundle H, tab 1, page 48. Where at paragraph 237 and over the page, if we could have 237 and the rest of it over the page, please. He says in the last sentence, after this and without waiving privilege, I forgot about it until I started to prepare my claim. So that's where the preparation of the claim comes into it. And we can see actually that he also says that he'd made a mistake in his reply. So that's at page 54, at paragraph 264 at the bottom. You can see what he says about his previous position in the reply, which has never been corrected, as I understand it.
Right.
So this is pretty key stuff for my client. It may not be for the company defendants, but pretty key stuff. And
but it can be dealt with, can't it? In the time till trial.
Well, I'd like to see those documents.
By have you asked for the? I know you've only just come into the case, but have people representing your client asked for these documents?
No. No. I don't believe we've raised any formal requests as things stand. No.
Right. Well, that can be done today.
Your Honour,
Monday.
I would hope it can be done promptly. I don't know how long it will take to search for these documents. As I say, we want a full review for the relevant period, not those 3 loose search terms or very inappropriate search terms. And that will be, no doubt, the genesis of a dispute as to what the search should be. But in any event, the claimant will want time to conduct that search. In the anticipation and hope that Your Honour is not called upon to resolve the dispute, I still need to see its product. before I can plead to the allegation, plead a defence, because it fundamentally changes the nature of the defence. And then with my skeleton argument due in 12 days, and everything else going on in terms of trying to review the bundle and so on and so forth, it's just not realistic in my submission. The other point that interposes is the vagaries of the pleading. Now, I've alluded to some of those in the skeleton argument. May I ask you to ask the EP, please? This is in my skeleton argument at
today,
today, sorry, at paragraph 5.
Yeah, I've got it.
If we can work backwards from 5.4, again, just essentially from passing the jurisdiction application skeleton argument, one sees that there is an unpleaded claim against my client. And again, these are claims in fraud, which the claimant intends to advance. If the EP wishes to pull it up, it's bundle G, tab 65, pages 27 to 28. But I've reproduced it, the skeleton argument.
Yeah.
So in order not to be ambushed at trial, I need to find out whether that is a claim that is being pursued. And if it is being pursued, the rules of the court require that it be properly particularized.
But if it hasn't been pleaded, it's not in.
Well, that would be my default position, Your Honour. But without taking any particular interest in it, I see from the dispute between the claimant and the company defendants in the strikeout application that there is at least the appearance that the claimant is asking the court to take a generous approach to the pleadings and admit of claims that aren't necessarily obvious on the face of them. And I also record that I've seen in the claimant's reply a reference to the accidental deletion of a cause of action and the insistence that it's maintained, even though the claimant has declined to serve a version of the reply that contains it. It's deletion of a sentence relating to DIFC law. So even just that suggests that the claimant doesn't seem to consider itself bound, and this is going to eat up a lot of time at trial if it's unresolved, because the parties have to prepare on the basis that it may be raised and it may be argued, and Your Honour may admit it. In the same vein, in the pleadings themselves, if we could open up, please, bundle A, tab 2, page 27, we have various pleadings, again, of the most serious nature against my client, which are neither particularized nor appear from my reading of this text, but it's not an easy document. I appreciate that Mr. Hill isn't the only draftsman in it, and when documents are amended numerous times, these things happen, but it's a very, very difficult document to understand, in my respectful view. But you have this kind of orphaned allegation of fraud in it. So you see at paragraph 80, the allegation is against Liberty DIFC, acting in repudiatory breach. That's the introductory wording. And you read that and you think, well, that's just an allegation against the company. But then you read paragraph A, and as you get through the paragraph, you get to the green text, which is the text which was added when my client was sought to be joined and then joined. And you have the allegation of a conscious attempt by Mr. Gupta personally to deprive the claimant of his annual contractual bonus. Now, the reference to Mr. Gupta in and of itself suggests that that intends to advance a claim. The word personally seems to put that well beyond doubt. The fact that it was added at the time that my client was added, was joined, implies that it's in support of a claim not previously advanced. It's not a particular of an allegation against Liberty, because if it was, it would be in red from when Liberty was, the previous amendments were made. So it's quite unclear what's going on there, but it seems inescapable that the claimant is going to seek to leverage it. And it won't escape Your Honour's notice that there are no particulars whatsoever of this conscious attempt to deprive the claimant of his bonus. The same occurs at 81, which is over page, I think. or if we can get to 81A, thank you. And you see the same addition in green in the middle. The consequence of that is, again, I don't know what information I'm seeking to elicit from my client, what case I'm seeking to answer, what documents I ought to be looking at this point. I don't know to what case I'm pleading, and there must be profound concern that the trial time.
Sorry, I don't follow. Why don't you know what case you're answering? I mean, you may say it's unparticularized, but the words are clear enough, aren't they?
No, because in the particulars of claim, the claims advanced against my client, ultimately, and when one gets to the remedies, don't include anything that seems to follow from this. So if in the same document, please, we can go down to 86.
Yeah.
I've just been showing you paragraphs 80 and 81. If we can go down to 86, you see the primary claim against my client refers to particulars at, I've got the wrong reference there. The particulars are given at 53A. Yes, there you go. So in the green text, by reason of the repudiation, wrongful termination and breaches as particularized at paragraph 53A. It's not clear to me what 80 or 81 go to in that. They're not in 53A. It's not obvious whether they're said for some other reason to be relevant to 282 or 285, but presumably they are. Or maybe they're given as allegations of repudiation and wrongful termination, albeit that my client isn't a party to the contracts. So that's the reason I don't know.
Well, the problem I have, Mr. Barrett, is that your client has had since July to ask these questions or to take steps earlier to bring the matters to a head. I'm not blaming you because you've just come into the case, but your client has had every opportunity. He's been represented, albeit by lawyers who no longer represent him. He's been represented in deciding what to do about the claim against him. And he could have asked all these questions.
Well, if I may speculate as to what the claimant might have said if he had, it would have been suggested that it was a submission to the jurisdiction. It would have been fundamentally incompatible.
No, but he needn't have waited till the 40th day of the 40th hour or whatever it was to issue his jurisdiction challenge.
Your Honour, I can't comment on the reasons for that further than I have. No. If it's 40 days, and what should be apparent from
when I say 40 days, there's a two-stage time clock. One from the date of the order until lodging, acknowledgement of service, or whatever it is, and then secondly, the period from then until he had to raise a jurisdiction challenge if he was going to, and that was quite a considerable period.
I think that's the summer span on the decision to challenge, and Your Honour, I've made my submissions on that. Essentially, he was challenging jurisdiction and was entitled not to participate until the court's jurisdiction had been determined, and faced the risk. And I've also said that a reasonable litigant shouldn't be required to engage a shadow team when his team is currently able to act in order to run a parallel case. Indeed,
someone's radio is on.
I've been so presumptuous as to mute them if you don't mind. The wonders of technology. To run a shadow team where there was a latent dispute, a latent conflict between the defendants, which has now come to crystallise in the circumstances set out in Davidson's letter. So essentially, he would have been getting ahead of a problem that his lawyers said, well, may come to pass, but hadn't come to pass, and running two teams and two sets of costs when it was to be expected wouldn't happen. And all that, because these claims weren't pleaded at the outset, all that because the amendments seeking to bring him in weren't made until more than 2.5 years into litigation, when trial was imminent. So the squeeze doesn't result, in my submission, from his, in my submission, perfectly reasonable conduct since the service in July, late July, of the jurisdiction order. It results because the amendments weren't proposed until so far into the proceeding. Proposed after amendment, proposed on the second amendment, proposed after 2 adjournments, proposed after it therefore follows document production, witness statements, the expert process. And none of that lies at the feet of my clients or even the corporate defendants, for what that matters. So it is a circumstance of the claimant's making. And if Your Honour were concerned by the tens of days which Your Honour describes, the reality in my submission is we still wouldn't be able to get to trial in a fair manner were he to have used those days. And that's apparent from the proposed directions attached to Al-Tamimi's letter today. I should say I haven't shown you some of the other disclarities in the pleading, but I think you have those. So I don't think the EP has this. This is the letter that's attached to my skeleton argument. And what you see is proposed directions to trial. And I've described this as whipcrack. It's really short turnarounds given the volume of materials, but this is a really concerted effort to not delay things and to make sure things come on quickly. So the starting date, for obvious reasons, is the date that we got access to the bundle, which is yesterday afternoon, late yesterday, in actuality. I still don't have a sign-on, for what it's worth. And the circumstances for that are described on the previous page of the letter.
Did you ask for them earlier?
I beg your pardon?
Did you ask for access to the bundle earlier when you had the
yes? So on
the decision without reasons.
Yes, on the previous page, if you go back a page, Your Honour, you'll see the full timeline for getting access. So you see it started quite a long time before. The initial delays, you can see, I mean, if we're talking about delay, the claimant delays by a day first approving the request, Al-Tamimi's request for consent to join the confidentiality ring. You see that in the first 2 rows. And then the claimant delays 5 days. On the Wednesday, the 1st of October, Al-Tamimi shares assigned undertakings with Davidson and Co. And you see it's only on the 6th that the claimant solicitors send an email to Opus to initiate access. And then there's back and forth with Opus, which takes a few days. So again, if one's counting days, that's 6 days of willful delay by the claimant. Inexplicable.
Yeah.
So then that's why we only have access now. It's not because of foot dragging by the third defendant. I've said, I do submit it's foot dragging by the claimant. So then one gets back over the page, the proposed directions. And the way Al-Tamimi have very, very helpfully laid this out is by the columns to explain the step, then the period that follows, then the date which the period entails. And one can also see there's a description of what has happened previously and how long the parties have had previously. And the first thing I invite Your Honour to observe is that all of these turnarounds are tight, are seriously tight. The second thing I invite Your Honour to observe is that all of these turnarounds are massively shorter than the periods previously afforded in the litigation, which would have been the periods afforded to my client if the claimant had pleaded its case in the first instance, or indeed the second instance, but it didn't. So these are super tight timelines that result from the claimant's delay. Where one gets to from it all is that it's about 3.5 months that the Christmas break adds an extra week of delay, or perhaps out of deference to Your Honour and to the experts because of where deadlines fall. But if we turn things around extremely quickly, we're looking at a period of about 4 months, which
About what?
I beg your pardon?
About how long?
About 4 months, slightly under perhaps. From the trial date, it's a bit less, it's 3.5 months. But call it 15 weeks, and 15 weeks is longer than the 40 days with which Your Honour was concerned. So we wouldn't have got to this trial in any event, is the thrust of my submission.
Yeah.
So the sum of all that is, in my submission, my client has acted reasonably at all junctures. To the extent that there has been delay, the delay is the claimant's first in advancing its case, and indeed advancing its case only after all of the procedural steps of trial had taken place, and indeed trial had been listed to take place twice. If, contrary to my submissions, Your Honour thinks it unreasonable that my client didn't instruct a shadow team in circumstances where his then current legal team was still acting and he was challenging jurisdiction, any delay that resulted from that wouldn't have saved, if it had been saved, wouldn't have saved the trial date.
Just to be clear, I'm not suggesting he should have instructed a shadow team, but that those acting for him could have addressed the matters before it became apparent, if it is apparent, that there was a conflict. They could have been working on his defence.
Well, I wasn't instructed for obvious reasons, so I can't say with first-hand knowledge. But what I can say is this: to the extent they had, and which is privileged, of course, but to the extent that they were, what they could do is constrained, or was constrained, by the risk of realisation of the conflict. Now, Davidson told you in their witness statement on the jurisdiction application that the conflict was latent at that stage, and Davidson's letter in September made the same point. It would be unfortunate, to say the least, and may have resulted in satellite litigation, had Davidson realised a conflict, made a conflict, by trying to get ahead of the procedural timetable. And that can't be in the interest of the overriding objective. It would have been very disruptive. And when one then looks at where we are right now, and why right now I still haven't had the chance to look at the bundle, it's because, as I've sought to show you, the claimant has dragged its feet in giving us access to the bundle. And so the claimant has engineered, to some degree, intentionally or otherwise, and I don't say this is it's not an allegation of impropriety, but through its conduct, the claimant has engineered even greater pressure on my client, and pressure that ultimately means that the trial date has to give, as regards my client. There may be issues, and we've proposed that there are issues that can be resolved between the claimant and defendants in the current window. But as regards my client, it simply wouldn't be fair to force him to proceed.
Shall I hear from Mr. Hill?
Thank you, Your Honour.
Mr. Hill.
Yes, thank you. I'm going to start with the timing of the defence and then address my learned friend's wider points. Starting with the defence, we submit Mr. Gupta knows very well the urgency of all of this and has known for some time that we would be pressing for a pleading and an acknowledgement of service in short order. He's had the particular claim since 11th of June, so more than 4 months. He's already set out his position at some length, dealing with legal aspects in his lengthy submissions on the jurisdiction application, and he's already dealt with factual aspects in his witness statements. So he only needs to deal in substance with relatively modest additions to the particulars of the claim as they relate to him, especially given he's already signed a statement of truth in support of the balance of the amended defence as it relates to the first and second defendants. So we do submit that, as well as finding an acknowledgement of service on the 13th of October, he can file his defence by the 15th of October. and we will provide a reply if so advised by the 20th of October. So that's the narrow point of pleadings. There's no need document production or witness evidence as we see it. The learned friend made in submission a new point about mistake and disclosure in relation to mistake. That missed the key point that in relation to limitation, what matters is our discovery of Mr. Gupta's involvement in the process. And the relevant date for that was his disclosure and witness statements in this litigation. That's the key point of timing. So my learned friend misses the point by seeking to go back further in time. But if there is a further point, it's something that should have already been raised some time ago rather than developed in submission at this hearing. They can write to us, and if there's a real point, no doubt it can be dealt with in short order without disrupting the trial. And what we do suggest, from the way my learned friend sought to develop the point, is he seemed to be making a point that related to disclosure points available to the first and second defendant already. And we are quite concerned that a lot of my learned friend submissions involve an attempt to rerun litigation points available to all defendants. The first and second defendants have had that opportunity. My learned friend's client was giving instructions to those defendants. And what wouldn't be right now is to derail the trial timetable so that we can have a reopening of areas of the litigation that have already been canvassed with the existing defendants. And that disclosure example he gave is one of them, because as the claim relates to his client, the key date is the witness statements and disclosure in this action. So that's our proposal for the timing of the pleadings. On my learned friend's side, we had no skeleton and no indication of their position until 11:30 this morning. We then had a letter asking for a response half an hour later by midday, and a skeleton note received half an hour after that. And although there's no application to adjourn, Mr. Gupta is in substance seeking an adjournment of a trial. And he sets out, as you've seen, directions for a trial at some time after February next year. And we do say that's remarkable, and we make a number of points. First, it's quite wrong to attempt to adjourn the trial by the back door. If that was the intention, there needed to be an application, and that application needed to be given to us and could have been given to us and the court with a lot more notice than a letter sent an hour and a half before the hearing. Secondly, the premise of the application is difficult to understand. Everything seems to hinge off the proposition that the new legal team has not had the opus bundle until the 9th of October. Now, that is a contrived submission for 4 reasons. First, the court has never been given a coherent explanation as to why it was necessary for there to be this new legal team. And even if there needed to be some new legal team, why one of the juniors from the existing team could not be co-opted to act for Mr. Gupta. Secondly, the timing of the access to the opus bundle is nothing to the point. All the parties have been conducting litigation until relatively recently without access to that bundle. The idea that the bundle needed to file a defence or to take other steps is nonsensical, and that's a fallacy repeated in Mr. Barron's submissions just now. It proceeds as if material can only be found in the opus bundle, but the pleadings and the witness statements and the experts' reports and disclosure have always been available, and indeed his client has always had access to them. Thirdly, even if there was some relevance in the timing of access to the opus bundle, it's clear from a cursory glance at the Tamimi letter that it is their side who have been dilatory in getting hold of it. This court dismissed the jurisdiction challenge on the 23rd of September. According to their own timetable, nothing happened until the 29th of December, so 6 days were lost. My learned friend then makes the unfair suggestion that it took us 2 days to approve their request for consent. But if you look at the timing, it in fact took us 1 day. They made a request for consent just before midnight on the Monday, and we responded with approval at 5:15 the following day, so not 2 days. There was then, looking at the Tamimi timetable, a completely unnecessary delay. But I should just say, given that nothing happened till 29th of September, 6 days were lost in that week. We then see in the following week a completely unnecessary delay until Thursday, the 2nd of October. And that's a delay that occupied most of last week. And I can tell you on instructions that on the 2nd of October, we shared Opus's details with Tamimi so that Tamimi could liaise directly with Opus. And most of this week seems to have been, looking at this timetable, seems to have been taken up with negotiations between Tamimi and Opus. And again, all very delicately. So to the extent there's any relevance at all in the Opus bundle, what the timetable shows is dilatory conduct on Mr. Gupta's side. But coming back to my wider points, the next point is that all the things that Mr. Gupta suggests need to happen before trial don't in fact need to happen. All we need is pleadings. There's no need for an RFI, as is suggested. The case is clear from the existing pleadings, and Mr. Gupta has already addressed the topic in his witness statement. My learned friend seems to suggest that he's confused by some of the references to Mr. Gupta in the claim, but it's entirely clear. We set out the particulars of fraud, deceit at paragraph 53A. There are then later points in the pleading that refer back either explicitly or quite obviously to the same allegations that we pleaded at paragraph 53A. My learned friend then makes another point that in one or two areas we've indicated in correspondence or submission that there are slips in our pleading and they're to be corrected. No point has been taken previously about the fact that we haven't served a version of the pleading making those corrections, and of course we can. So there's no point that arises there. And of course on this, as with all these points, my learned friend could have asked us about them. He could have asked us about our disclosure. He could have asked us about our pleading in the previous several months, and he could have done so without without submitting to a jurisdiction. Perfectly possible to do that while preserving a position on jurisdiction.
Your Honour, may I answer some of that?
No, I'm still
Just
carrying
pausing.
on.
Sorry. I was waiting for Mr. Hill to look up in case he had more
Yes.
to say.
I'm just carrying on. Just to come back to the Tamimi letter, what you can see from the various directions they propose for trial is a series of completely unnecessary steps. For instance, they seem to expect that Mr. Gupta is going to get involved in expert evidence. We've already had the expert evidence. It's been given by the defendants on instructions from him. There are no new issues of expert evidence that single him out. His position on the expert issues is the same as the first and second defendants. And that's just one example of what Mr. Gupta seems to expect, which is to rerun existing points of the litigation which are common to all defendants. And that's not necessary. So the bottom line is that this is a request for an adjournment without an application to adjourn, and we submit the court shouldn't entertain it. And it is worth mentioning that the adjournment that's proposed would cause immense prejudice to my client. As I said in the previous hearing, I couldn't do a hearing of this trial at any point after December. So while potentially an adjournment to December could have been accommodated, the idea of there being a trial in February means that I can't do the case. And he would lose my representation. My client is an individual. He's not in the same financial league as the defendants. And this would put him to an enormous financial burden in litigation that's already been running a long time. My learned friend suggests that this is somehow our fault in that we joined him late in the day. But we didn't join him that late in the day. And had he attended to matters expeditiously after we had sought to join him in June, none of this would have arisen. And I should say there should be no criticism of us leaving it until the time we did to make the application to join Mr. Gupta. This point's been raised before and we've addressed it. The key factor that meant that we could fairly plead the claim against Mr. Gupta, which we did, arose from his witness statements and previous disclosure, which made it clear exactly the extent of his involvement on his case, on what we say, and indeed we say on his case, amounts to deceptive conduct. Thank you.
Thank you. Mr. Barron.
Yes, sorry. I think most of that doesn't really need a reply, but there's a bit of an air of unreality in the suggestion that Mr. Gupta is seeking to reopen things which he shouldn't be entitled to, that he should only be entitled to advance a position on whether he misled Mr. Kahlon. As Your Honour is very aware, amongst other things, my client's interest in the validity of the written agreement is diametrically opposed to D1, D2. He has to be able to interrogate that. He has to be able to interrogate the law, the governing law, and the facts around the execution of those documents in his pleading. So there's no world in which, even were he to be made the subject of an order restricting his participation, for which there is no application either, which is highly inappropriate, would need, as an abrogation of natural justice, would need some considerable justification in my submission. He still would be pleading much more widely than Mr. Hill suggests. There's also an air of unreality in the suggestion that, as Mr. Hill puts it, all we need is pleadings. That's, if I may say so, a nonsense. The court needs a skeleton argument as well as the pleadings. It needs the pleadings first, needs a skeleton argument from me, needs my submissions orally, needs cross-examination, or whoever makes submissions. It needs
To be clear, I'm
the
not
assistance of the parties.
I accept all of that, to be clear. I'm talking about interim steps.
Well, I'm grateful. So with 2 weeks to go, we got the Court of Appeal's decisions this morning. That's going to require some serious advice because it goes to a number of things. There are too many works.
You got a decision a couple of days ago, didn't you?
No, we got it an hour or so before this hearing.
I thought you got the reasons today, but the decision.
Yes, the reasons. Yes, of course, but the decision and its consequences and what follows from it couldn't be scrutinised without the reasons, Your Honour.
I see.
Of course, a challenge is to an order, but the premise of the order was wholly unclear. And I say that without disrespect at all to the Court of Appeal, to the Chief Justice, but the order is in ball terms and we couldn't comprehend it. So there's an awful lot going on there. Just as a point of detail, it's important to say two things. The first is, and I'm sure Mr. Hill didn't mean this, but it would be inappropriate, and you haven't been invited directly at least, to go behind Davidson and Co.'s letter in which they said that the legal team had decided to cease to act. There was more than a hint. I think there was a direct suggestion in Mr. Hill's submission that this was something that Mr. Gupta has manufactured, and that maybe a junior barrister could have come across, and there were other ways to deal with this. Davidson's letter, and we can look at it, perhaps we ought to look at it, is quite clear, and that's a letter from solicitors who are officers of the court. So it's at Bundle K, tab 971. I know that's not right, I apologise, that's the wrong, it's L 11. Fear I've got that wrong too. No, I apologise. I've got it this time. K 1036.1. And if we could just have both pages up, please. If I could ask you to read it, please, Your Honour. You see at paragraph 5 that Davidson and Co. say they concluded that they could no longer act for Mr. Gupta. Now, I don't propose to pry into the reasons for that. these are experienced lawyers, and that's their assertion.
Yep.
The other point of detail is the equality of arms in terms of access to lawyers. And there are 2 points here. As regards my client's access, when Mr. Hill was describing delay, he omits to recognise that the notice of change of solicitors was served on the 25th of September, not prior. But it won't escape anyone's surprise that, as I've mentioned in the skeleton argument, when you have litigation of this sort with costs involved, funds for lawyers have to be realised and transferred around the world. There are big sums. It's not an overnight process. So it's to be expected, and I'll say no more because I cannot waive privilege, that things haven't been up and running immediately at full steam from day one. Conversely, despite Mr. Hill's protestations as to his client's apparent impecuniosity, an impecuniosity rather given the lie by the quality of the legal representation he has, I'm instructed, and I'm instructed also that Your Honour will know more about this than me, that the claimant has sold recently or has $100 million of crypto. So he, and I understand this may ultimately be a point of dispute in the parties on mitigation. He is very, very well resourced, and that's evident from his representation today. Your Honour, those are my submissions.
Hang on. Can everyone hear each other?
Yes.
Yes.
Yeah. I've seen correspondence about that. I'm not going to make a ruling or make a finding one way or the other. But I take your point, your broader point, that money needs to be put in place before your client can instruct a new team of lawyers. But as I understand it, that's been done.
To a degree, I'm here today.
Yeah. Very well. Anything else you wanted to raise?
Your Honour, no. I should just sort of, I'm not taking a point, and I seem to take a point that I'm not taking. The point about the bundle is that's where all the documents are and where the confidential things are and where I can get access to things. Of course, there are other bits and bobs here and there that I've seen, and that's apparent from the permission to appeal skeleton argument. But in terms of access to the material in the case, that has come with the bundle for me.
Right.
Can I just for the record, since the point's been raised, there's an unpleaded point about my client's means and resources. It's irrelevant to the case, but it just to be for the record, that's not accepted, the suggestion that was made about my client's resources.
No, well, as I said, I'm not going to enter into that or make a ruling, finding one way or the other. Well, Mr. Barradon, I understand that it will be hard work for a team of lawyers coming into the case at this stage. It doesn't seem to me, though, that it's impossible. I'm particularly struck by the, I accept to a significant extent Mr. Hill's point that your client is unlikely to need to plead to the vast majority of the stuff written in pleadings to date, and he will have to plead, of course, to the matters directed at his involvement. But I find it, I don't accept at the moment that there is likely to be a need for him to replead the whole of the defence for his own interest. And, and that being the case, and the time still being 2 weeks to trial, I'm not prepared to adjourn the case of this. And I'm going to lay down a time for service of defence. Mr. Hill says Wednesday the 15th. I don't know whether Friday the 17th would help you.
I can't, well, I certainly can't do it for them. I don't know what the position of the third defendant will be.
Right. what I will do is I'll make an order that any defence be filed and served by, I'm going to say Friday the 17th, 4 p.m, with a reply still on Mr. Hill that's going to put your team to work. Reply by close of business on the Monday the 17th. Sorry, 20th. You're muted, Mr. Hill.
I apologise. Yes, we will have to comply with that.
When I say close of business, I mean 4 p.m. Gulf Standard Time. And,
My lord,
sorry, I was going to say any pleadings within those time limits should not only be filed with the court, but intimated directly to the other party, just in case the court on a Friday afternoon doesn't pick up the service of the documents. Sorry, Mr. Barrett, you wanted to say something?
I think
Your Honour, that was my interjection. I wonder if I might just be heard on a short point in relation to the claimant's reply. The company is very concerned, given all of the unpleaded points that are currently an issue, that the reply to Mr. Gupta's defence is going to be used by the claimant as a vehicle to introduce various new points on questions that are already in issue against the companies.
Let me make it clear, as far as I'm concerned, a reply is a reply. It's not an opportunity to introduce new claims. If it does seek to introduce new claims, you can have your shout about it.
Yes, Your Honour. In fact, my concern goes a little wider than that, because the problem also arises if the claimant seeks to introduce new points that don't necessarily constitute new causes of action, but which relate to issues which are common to Mr. Gupta and the companies. So, by way of example, the claimant currently sets out his position on the manner in which LTIP vested. We don't want to see some new case in relation to that emerging in the reply. Equally, there's been various pleading about the governing law of the question of mistake, for example, or the grounds on which a contract can be rescinded. All of these things concern the companies and have been fully pleaded in the existing pleadings. And what we don't want to see is the claimant trying to patch up the deficiencies in his pleadings in a reply that's served on the same day as his trial skeleton argument. It would make things unworkable from our point of view. And so in my submission, the reply really should be confined to any new points that specifically arise in relation to Mr. Gupta.
I should have asked, you're not proposing to serve any reply to Mr. Gupta's defence, Mr. Trotter, are you?
Well, Your Honour, we don't know what that defence will say.
Okay.
So I can't really confirm the position.
Mr. Hill, do you accept that the reply to Mr. Gupta should be confined to matters relating to Mr. Gupta's defence?
Yes, I do. And there's an element of chicken and egg here. What that underscores is the importance of Mr. Gupta himself keeping his pleading to the matters that concern him, and this not becoming a vehicle for him pleading new points on common issues.
But I take your point on that, but I can't make a definition in advance of precisely what is allowed to be pleaded and what isn't. So we'll just have to cross that bridge when we come to it. Mr. Trotter, Mr. Hill accepts that his reply should be confined to matters relating to a reply to matters raised by Mr. Gupta.
Thank you, Your Honour.
If it goes further than that, everyone can have a complaint in due course.
Thank you, Your Honour. I'm concerned about the time that may occupy on the first day of trial, but we shall endeavour to avoid that.
I hope so.
Your Honour,
we've taken longer than. Sorry,
may I ask, please? It's implicit in your ruling, but my client is debarred from adducing witness evidence or making an application for further information or disclosure. Three separate limits. Because he's practically debarred, but is he debarred by order?
No.
But when is he ordered to take those steps, please?
It is my view that he can take those steps. He ought to take those steps as soon as possible if he's got any, if he wants to take those steps. Mr. Hill, I don't suppose you have a particular time limit in mind, but the later he leaves it, the more difficulty he'll have in persuading the court that the other side are at fault in not responding.
My lord, that's right. I mean, Your Honour, it's right. I'm not sure we accept there are any steps it's necessary to take, but he must take his own course, and we will respond promptly to the steps that he does take.
Yeah. All right, Mr. Barrowland.
Thank you.
Mr. Trotter, I haven't really. Sorry. Yes. Who's speaking there?
Next on the agenda is the supplemental experts report, which you put on the registry put on the agenda in the first place. That's my application.
Yeah.
And at the outset, it's worth looking at paragraph 12C of the court's order of the 21st of October 2024. That's at bundle C, if EP could put it up, bundle C, tab 16, page 3. And the paragraph 12C, paragraph 12, directions were given in relation to expert evidence. And you'll see from the top, the claims defence had permission to rely on evidence of experts in the mining and steel industry on 3 topics, and the last of them was the quantification of the LTIP. So 2 points. 1, the direction related to quantification. 2, the limit in the order on the fields of expertise is experts in the mining and steel industry. What has happened is that defendants have adduced an additional expert, which is evidence from Mr. Ashton, who's not an expert in the mining and steel industry, but an accounting expert. So their expert evidence goes outside the fields permitted by the order. We haven't so far.
So when did they produce that?
That was in the first round of evidence.
When was that?
That was in March. Was it March? So we haven't sought to exclude his evidence of being outside the fields directed, but technically the defendants would need to seek permission for it. But assuming Mr. Ashton's evidence is coming in and we don't seek to exclude it, it creates an immediate inequality of arms arising from them serving evidence outside the fields directed. So the starting point for our application is that even if you don't take into account the additional difficulties arising from their disclosure of financial material and their late confirmation, but they weren't going to improve their disclosure, we should be entitled to put in accountancy evidence to answer the accountancy evidence put in by the defendants, which went outside the permitted fields of expertise. And the time for us to was in our reply expert evidence, which was filed on the 8th of September. And I'll come back to the additional delay on that. So that's the starting point. We then had the exacerbating factor of the financial disclosure. The exercise for the experts essentially involves looking at EBITDA levels for the relevant businesses and the relevant periods, assessing their growth, and on that basis saying whether, on certain assumptions regarding contractual interpretation, the LTIP trigger was or was not met. Now, that exercise should have been readily capable of being done on the basis of monthly management accounting information, which ordinarily would give monthly EBITDA figures, or from which they could easily be derived. Had that information been provided in the usual way, Mr. Cowley, who's an industry expert, not an accountant, would have been in a position to conduct the LTIP quantification and speak with comfort on those aspects on the basis of the information supplied. That information has not been forthcoming. It wasn't forthcoming by the time of service of Mr. Cowley's first report, although at that stage we were still hopeful that we could get it. But by July 2025, the defendants had declined to produce it. They said it wasn't in their control, and they said they didn't think they could get it even if they asked. And we deal with that at paragraph 10.4 of our skeleton. So it was against that background, where we couldn't get that material, where the defendants, well, I should say against that background, the defendants themselves clearly took their own decision to serve expert evidence from an accounting expert. And what he does, what Mr. Ashton does, is use his accountancy expertise to try to derive EBITDA growth levels on the basis of such information as is available. And in particular, what he does is he takes statutory accounting information, not management monthly accounts, and seeks for various different periods, for the various different units, and then tries to do an exercise to calculate EBITDA levels. Now, the details of Mr. Ashton's, that's the defendant's accountant's expert evidence, are quite involved.
Mr. Hill, sorry, we lost you, or I lost you for about 30 seconds. So can you just repeat the last 30 seconds worth?
Yes. So what I was saying, it was against the background of the monthly management accounting material not being available. The defendants clearly made their own decision to adduce expert evidence from an accountant outside the permitted fields of expertise. And what Mr. Ashton does is he seeks to derive EBITDA figures and EBITDA growth levels not from monthly management information because it's not available, but instead taking statutory published or statutory legal accounts, and then which for the various different business units relate to different periods, and then conducting quite a complex exercise of trying to derive what he says are the EBITDA levels to be drawn from them. Now, the details of all that are quite involved. You can see the points summarized, in fact, by Mr. Lazarevich, our proposed new expert, at paragraph 10.3 and 10.5 of our skeleton that Your Honour has.
Yeah.
And we give two quotes there, which set out what is effectively common ground among the experts, that the exercise of working out EBITDA levels could have been done more easily with the monthly management accounts. But in the absence of that, Mr. Ashton for the defendants has done a process of adjustment and estimation, all of which is an expert's accounting exercise of some complexity. And again, all made necessary because of the lack of consistent monthly management information. So that's why the defendants found it necessary to have Mr. Ashton. And just to give an example of what Mr. Ashton, their expert, has done, if we can pick up his report at bundle I-28, page 8. Starting at section 2.8 is a section entitled Financial Information Provided. And that runs over the next 10 pages through to page 18 and paragraph 2.33. And in this entire section, we see Mr. Ashton setting out quite a complicated estimation and adjustment exercise that he as an accountant has had to do with the limited information provided. And just to pick up just a few examples, top of page 9, he says, had to use comparative figures for prior periods and relevant accounts in order to establish a full set of data across the whole of a time frame, time available, not being able to review and interrogate the accounting information in as much detail as he wants to. Then page 11, look at paragraph 2.10. Explains that information is provided for extended accounting periods only, generally 1 year, not exclusively, while helpful in relevant instances to be able to rely on finalised and audited accounts. Not possible to understand the profile of how any relevant revenue and profits were generated across relevant periods, in contrast to periodic management accounts, which would normally allow for a monthly view to be seen. This is an important factor and limitation when attempting to analyse growth over specific timeframes which do not align with the periods of the accounts. And then lower down that page, 212, as a consequence of the above issues, in most instances underlying method 1 calculations, I've had to prorate the figures from one set of accounts and add the resulting amounts to another set of prorated figures from a different set of accounts in order to derive figures that can be used and compared in my analysis. 213, this is a significant simplifying assumption in terms of how revenues and profits are assumed to accumulate during the assessment period and or base period. In my opinion, the need to apply this assumption significantly impairs the usefulness and accuracy of analysis. In the absence of more detailed management accounts, which would, among other things, allow a monthly view, I consider my method 2 calculations to be more reliable in this respect, even though they may not align directly with the 4 method 1 assessment periods referred to in paragraph 2.1 above. Then over the page at 216, the different formats and levels of disclosure given across the different sets of accounts means it's not straightforward to ensure consistency in terms of what is included within or excluded from relevant metrics. For example, certain accounts specifically identify EBITDA figures, whereas others do not, and may not include the requisite level of information to straightforwardly calculate EBITDA. And then page 16, at the bottom, 226. As already referred to, in a number of instances, the exercise involves prorating of financial information in a simplified manner, such that the estimated 12-month performance for the period in question may be materially different to how the 12-month performance would be calculated if I had access to monthly figures. Again, in my opinion, the need to apportion financial data in this way significantly impairs the usefulness and accuracy of the analysis. And to that extent, my method 2 analysis will be more reliable. And then at 228, says again, it can be seen from the above, but although these do not align precisely within the timeframes, this is dealing with his method 2 now, these do not align precisely within the timeframes for the analysis of method 1. They are broadly similar. Sorry, could the EP screen blow this up a bit? 228. Thank you. They are broadly similar and all start within a 6-month period of each other. In the case of Liberty Ostrava, the need to derive an annual period for comparison purposes from the accounting information covering an 18-month period necessarily renders any analysis of the company less reliable than in the other cases. So that's just a snapshot of the sort of quite complicated exercise that this accountant has had to do on the basis of the statutory figures to try to derive EBITDA figures for the purposes of calculating EBITDA and EBITDA growth in the absence of the monthly management information. So in those circumstances, we submit there should be no question, but that we would ordinarily be entitled to adduce expert accountancy evidence in response to this. 3 points. First, it responds to expert accountancy evidence, which itself falls outside the permitted fields, so it ensures equality of arms. And indeed, it would be surprising if a defendant were permitted to adduce this evidence going beyond the court's direction, and the court had to attempt to grapple with it without having the benefit of an answer to it from the claimant's own expert. Secondly, this all arises from the fact that the defendants have not themselves produced accounting information which must have existed and which is consistent or reliable and would enable the exercise to be conducted in a way that less requires this kind of estimation and expert assessment by an accountant. Thirdly, it'll be helpful to the court itself, because otherwise, on an exercise that has become more complicated and requires more accounting expertise than one might ordinarily have expected, the court will only have one side's expert and will not be assisted in testing and scrutinising the defendant's expert evidence. So that's why, in our submission, as a general matter, it would be right and appropriate for this evidence to go in. It does provide the court with an expert view from an expert appointed by the claimant as to what you are to make of the disparate accounting information provided and what conclusions can be fairly drawn about EBITDA levels and EBITDA growth. And the time at which that needed to be adduced was at the time of evidence in reply, not earlier. The defendants have suggested that this should have been adduced as evidence in the first round in March. But that overlooks the fact that the defendants have themselves gone outside the scope of the expert fields permitted by the court. Yeah. And if we had done the same, we would have been in breach of the court's directions, as indeed they are. And secondly, the need for us to produce this evidence only really fully crystallised when it became clear that we weren't going to get a set of monthly management accounts, which would allow us to do a simple exercise on the EBITDA levels. So We do submit, but if we had adduced the evidence at the time of the reply evidence on the 8th of September, all would have been in order. And that was indeed our aim. And it's worth mentioning that we did foreshadow this at the PTR in July. Now, turning to the evidence itself, Your Honour will have seen the evidence of Mr. Lazarevich at G210. It's not long. It has two sections, two operative sections. Section 2 comments on Mr. Ashton's exercise generally, and that's useful. It's useful for the court in understanding the issue, and it's useful in assessing the expert exercise of adjustment and estimation that Mr. Ashton has been conducting. And then section 3 gives Mr. Lazarevich's own conclusions as to the EBITDA levels that can be ascertained from the information, again commenting on Mr. Ashton's approach and giving his own summary of whether on certain assumptions about interpretation, which is not his exercise, whether that means the LTIP requirements were or were not met. And again, all of that is helpful to the court and exactly what the court will want to assist it. So can I just then turn to the timing of service of this report? Because while it should have been in at the reply deadline of 8th of September, it wasn't. And we didn't.
A funeral intervened.
That's right. So what happened was, regrettably, Mr. Lazarevich's mother died over the summer. And that meant not only was that there was the bereavement, but also he was organising his mother's funeral. And the result was that while we wanted to have a draft provided to us and finalised and then served by the time of the reply evidence on the 8th of September, that didn't happen. We didn't get from him a substantive draft of his evidence until the 17th of December.
Yeah.
We turned that around very quickly. He wrote to the court on the 26th of September to state that it would be filed shortly, and it was filed on the 29th of September with the application and witness statement of Mr. Singh. So we do invite the court to allow in this evidence. I do accept that because of the delay between the 8th of September and the 29th of September, we have to satisfy the requirements of RDC 449, and we do meet those requirements. And if I could just run through them. First one, interest in the administration of justice. But we do submit this is important to get to the bottom of a absolutely central aspect of these proceedings, which is the quantification of the LTIP, potentially valued at $30 million. And the court will be facing a significant asymmetry and inequality in the evidence if it's not admitted. Secondly, whether the application has been made promptly, and it has. The defendants, for the reasons I've said, are wrong to suggest this could and should have been adduced in the first round, which would have been contrary to the order. And what made it most necessary was the confirmation, which didn't come till July, that we would not be getting management accounting information that would make the exercise manageable. My learned friend suggested his skeleton bits was all some kind of a pretext. That's quite wrong. We wrote letters absolutely correctly identifying what information was necessary, and it's information that should have been available. What is surprising is the fact that it was not made available, and that there was a suggestion that it hasn't not in their control and couldn't be obtained. If it had matters run as they should have done, we would have expected to receive the management accounting information, and we would never have needed to have an accountant because the exercise could have been easily quantified. We then did, on receiving that confirmation in July, we did act promptly. Matters were delayed because of Mr. Lazarevich's mother's death and him organising the funeral, but that was outside of our control. And as soon as we got a draft response from him, a draft report from him, we turned it around extremely quickly and served it and applied for permission. Now, next point, whether the failure to comply was intentional and caused by the legal representative and whether there's a good explanation. The failure to comply was not intentional or caused by the legal representatives, and there is a good explanation, being in particular the bereavement, which delayed Mr. Lazarevich. Next point, the claimant's conduct and compliance with other rules. We did flag that the supplemental experts report may be forthcoming at the PCR in July. That was the first opportunity after the defendant's confirmation that we wouldn't be getting monthly management data. And so we were transparent with the court about that. And I should just say, there's a suggestion in Malone and Friends skeleton that we've been generally non-compliant. We don't accept that. We do accept there was a criticism made of our disclosure a long time ago, but we haven't generally been non-compliant. And indeed, in recent months, I would suggest the non-compliance has all been on the other side of the fence in this case. Trial date, we don't accept there'll be any impact on the trial date if the relief is granted. The expert report deals with an important point, but a narrow point, about calculating EBITDA levels on the basis of the limited information provided. Secondly, Mr. Ashton, who's an accountant, has already given his evidence on this point, so their evidence is already in on it. Thirdly, because Mr. Lazarevich is a responsive point, there's no need for further expert meetings or joint memoranda or anything like that. That wouldn't naturally happen because his report could fairly be served as reply expert evidence. But if the court thought it was helpful to do that, there's still time for a short report, short joint memorandum, which is all that would be necessary, and indeed a meeting. But that isn't necessary. Next point: effect on each party of the failure to comply. There are three aspects here. First, the effect of not allowing this evidence in would be that there would be a significant inequality in arms, and the defendant would have the benefit of an accounting expert, and the claimant would not. Secondly, the effect of the claimant's inability to file a supplemental report would potentially deprive us of highly material evidence going to the largest head of loss in the claim, in circumstances where we're certainly not responsible for the fact that monthly management EBITDA information hasn't been forthcoming. And thirdly, save that we accept, had around 2.5 weeks less time with the supplemental experts report than they should have had. There's been no effect on them with regard to the failure to comply. And so we do submit that the real effect of granting relief will actually assist the court, prevent inequality of arms, and we will be able to rely on a report which is highly material to our claim and to everyone's understanding of the actual EBITDA growth levels. I'm grateful.
Thank you, Mr. Trotter.
Thank you, Your Honour. I'm afraid Mr. Hill has very badly misunderstood the background to all this, and it's no criticism of him because, of course, he wasn't instructed at the time. But can I start with the suggestion that the expert evidence that the companies have adduced is outside the ambit of the permission, because that is wrong. If we start, could Opus please bring up the order at C/16? This is the order that Your Honour was taken to. And if we go over to page 3, this is the order that Your Honour made at the restored CMC in October last year. And paragraph 12 is the paragraph that Mr. Hill took you to. It says the claimants and the defendants have permission to rely on evidence of experts in the mining and steel industries on certain issues. Now, the transcript isn't in the bundle, but Your Honour may recall that I expressed at that hearing some concern about whether the same expert would be able to deal with all of these issues, given that the first two concern market practice and the third concerns an accounting exercise. And there was there were submissions made at that hearing about whether the lawyers should be reaching for the forensic accountants or could simply do the numbers themselves. And Your Honour formed the view that it would be better to have assistance on that point. Now, there was a subsequent order in the light of that concern, and that is at C18 of the bundle. To bring that up. This is the order that Your Honour made on the claimant's disclosure application, which was heard in January. Your Honour may recall that that disclosure application took 2 days, but at the end of the second day, there were some submissions about various matters of case management. And if we go over to page 5, we see there's a bold heading, witness and expert evidence. And at paragraph 10, paragraph 12 of the second CMO, which is the order that we've just seen, be amended so that the claimant and defendants have permission to rely on the evidence of experts on the following issues. And Your Honour sees that that permission is therefore no longer qualified or confined to evidence of experts in the mining and steel industry. And that was precisely because of the concern that a mining and steel industry expert would not be in a position to deal with the quantification of EBITDA and so on. So insofar as my learned friend suggests that there'd be some ground to exclude Mr. Ashton's evidence, or that they didn't see this coming, that is wrong. Of course, Mr. Hill may not be aware of it. I need to reiterate, I make no criticism of him at all, but that is not how matters unfolded. Now, to add to that, Mr. Ashton's report was then served over a month before the report of Dr. Cowley. And Your Honour will remember, I'm sure, the various extensions of time that were required in the lead up to those deadlines, and putting it neutrally for the moment, ultimately the inability of the parties to comply with various deadlines led to the adjournment of that trial. And Mr. Ashton's report was served on the 3rd of February 2025. Dr. Cowley's report was not served until a month after that, on the 7th of March 2025. And there was a suggestion in correspondence at the time from KBH that they weren't going to open the reports and read them, but they plainly saw that there were 2 reports when the reports were emailed to them. And our position was that that was a matter for them. If they didn't wish to read the evidence that had been served on them, then that was a matter for them to choose. There was no reason why they ought to have done so, or why they were required to refrain from reading the evidence that our clients had served. So it was plain as day to the claimant from October 2024, certainly from January 2025, and without a shadow of a doubt from February 2025, that the companies were going to rely on accounting evidence in relation to the quantification issue. And it would have been perfectly open to the claimant to do the same thing, and he elected not to do so. That's the first point. The second point is that my learned friend's position hangs almost entirely on his contention that it would have been permissible simply to introduce a brand new expert in supplemental evidence. Your Honour, that would make a mockery of the process that Your Honour set down at the October 2024 restored CMC. And we've seen that order a moment ago, but just to bring it up again, if we just go back to C/16 and over to page 3.
What date is this?
This is the order from, it's dated the 21st of October 2024. This is the order that Your Honour made at the restored CMC last year. Yep. And the process set down is a familiar one. It's the same in many orders made in many cases in this jurisdiction and in others. But there's 12 permission to rely on experts, 13 a date for expert reports, 14 there shall be a meeting between the parties' experts, 15 the parties' experts shall produce a joint memorandum, and then 16 there shall be supplemental expert reports. Now, it need hardly be said that the people who are going to serve supplemental expert reports are the same ones who have gone through the process of the meeting and the joint memorandum, because the whole purpose of that process is to whittle down the issues on which they agree and disagree and the reasons for that. And the product of that process is a helpful table that sets out each expert's view on particular issues and identifies the reason for the disagreement. But Your Honour, that whole process goes out the window if the parties simply start throwing in new experts at the very end of that process in the lead up to trial, because they decide that they want someone new to address the same issue. And imagine that the companies had decided in supplemental reports, actually, we'd like someone in the mining and steel industry rather than Mr. Windmill, who is essentially has HR experience more generally, to address the market practice issues. We would have said, well, we're going to need another expert, given that Dr. Cowley approaches this from a different background. So we'll serve a brand new expert report from a brand new expert together with supplemental reports. It would have been met with howls of objection from the claimant. And the reason we didn't do that is because it's not contemplated by the order, it's not necessary, and we appointed the experts that we did based on the directions that were given. And the claimant ought to be expected to do the same. That's the second point.
Do you accept that if this evidence is not allowed in, the result will be the court has evidence on a certain point which is not contradicted?
I don't accept that at all, Your Honour, because Dr. Cowley, for the claimant, has already addressed the quantification issue at some length. And perhaps I should show you that. So his report is at I/1. It's a 37-page document. And one sees from the table of contents what it addresses. If we turn over to page 2, first we have issue 1, industry standard practices about EBITDA. That's the question of whether EBITDA is such a standard metric that wasn't really necessary to actually put it in the agreement. Issue 2, standard practice in relation to vesting. That's the question about does one get an LTIP, a long-term incentive plan payment, even if one doesn't stay for the long term. And then over the page 3, we have issue 3, the quantification of any LTIP that, if found to be payable, would be due in these proceedings. And we can see that being developed from page 24 of the report. So in this section, I assess the quantification of LTIP payable. When examining EBITDA calculations, one must consider the nuances, significantly impact the accuracy and relevance of the metric, so on and so forth. And we don't need to conduct a granular dissection of this report today, but one sees, first of all, at 6.1, there's a discussion of the various methodologies that might be employed. Over the page to page 25, should we calculate it cumulatively or over the entire period? Over the page to page 26, under 6.5, we have the assessment of whether the LTIP performance goals were achieved. This is the quantification issue that Your Honour directed and that Dr. Cowley has been instructed to calculate. We see the various business units there listed, A through to D. We go over the page to page 27. We then have various tables that set out Dr. Cowley's calculations. So table 1 in relation to primary steel Europe, that's Galati, Skopje and Ostrava, which one sees in the tables there. Over the page 28, we've got the calculations done for MPS, which is 2 of the Australian business units. Over the page again, at the top of the page, we've got LBB, that's Liberty Bell Bay, which is the remaining Australian business unit. And if we go over finally to the page 30, we see what Dr. Cowley's conclusion is at paragraph 117, and he gives evidence that, in particular, if the claimant had remained employed for the 3-year period, then he would have met the 100% threshold. He says in the middle of that paragraph, there's nothing to indicate in the documents that I've seen that the performance of the business units would be declining over the relevant months leading to the conclusion of the vesting period of 3 years. And so the claimant has an expert who has addressed the quantification issue. He's then done a joint memorandum with Mr. Ashton on this very issue. Perhaps we should bring that up as well. That is at I/36. So there have been some detailed discussions about this between the experts. There's various introductory matters, including the summary of instructions. If we go over to page 3, we see what Dr. Cowley was instructed to do under paragraph 1.10. He's been instructed to address all 3 of the issues that Your Honour directed. Number 3 being the quantification of any LTIP that may be found to be payable. And then if we go over to page 5, again, we don't need to go into all the detail of this, but just to get a sense of the scale, we've got 2A, the approach to measuring growth, and each of the experts set out their differences in relation to methodology. Over to page 6, we've got issue 2B, should it be done individually or collectively? Over the page to page 7, 3A, should the metric be adopted subject to adjustments? That's the point about whether, for instance, it's sensible to be paying executives based on EBITDA alone when EBITDA is affected by wildly fluctuating steel prices. Oh, I'm sorry. Is the judge... Is everyone still here? I'm not quite sure how long I've been speaking to myself. So
I was listening to you,
wait.
Andrew.
I'm glad someone was listening.
Guess we'll wait.
Thank you, counsel. The registry will quickly check with the judge, please.
Thank you.
Thank you for waiting.
Your Honour, I apologise. I believe
I've been cut out for about three minutes. So I'm afraid I saw you when you were on the cover sheet of the joint memorandum between the experts, but I lost you then. So I don't know how long ago that was.
Your Honour, that wasn't, mercifully, I wasn't talking to myself about the joint memorandum, at least on this occasion, for too long.
Right. Do you want to go back to that point there?
Yes, perhaps if we just go back to page 2 of this.
I should say I don't know. I'm using my phone as a connection now, so I don't know whether it will work. So bear with me if it doesn't.
Thank you, Your Honour. So we were in the joint memorandum, and I was making the point that the claimant has already had an expert who has addressed this quantification issue in quite some detail. This is the joint memorandum between Dr. Cowley and Mr. Ashton, the accounting expert on our side. If we go over to page 3, we see paragraph 1.10, what it was that Dr. Cowley was instructed to do. And he says, Dr. Cowley has been instructed to address 3 issues. And Your Honour sees that those are the same 3 issues that were permitted under the order made in October 2024 as subsequently varied. And so the claimant has made a decision to ask Dr. Cowley to address the quantification issue as well, which we see at subparagraph 3.
Yeah, sorry, remind me, what date was this joint statement?
This joint
August,
statement,
19th August, I see.
19th of August, yes. So Dr. Cowley's, Mr. Ashton's report is served on the 3rd of February, 2025. Dr. Cowley's report on the 7th of March, 2025. There's then some delays in coordinating this joint statement, which is finally produced on the 19th of August, 2025, after a meeting between the experts. And we don't need to, again, go through all of the detail, but just to give Your Honour a sense of the scale and the detail of this document, if we go over to page 5, we have issue 2A, approach to measuring growth. So each of the experts sets out their slightly differing methodologies. Then over to page 6, 2B, the experts are discussing, should growth be measured by reference to each of the individual business units, or should they be calculated collectively? Over to page 7, issue 3A at the bottom of the page, should the metric adopted be subject to adjustments? And that's the issue of whether it's sensible to take EBITDA alone as an executive's remuneration metric, or whether one needs to leave out of account things for which they cannot take credit or blame, such as, for example, the wildly fluctuating steel prices during that period. And then if we go over, that continues for some pages. If we go over to page 10, we have the appropriate metric for evaluating growth, and Mr. Ashton discusses various other metrics that he has considered. Dr. Cowley has confined himself to EBITDA. Go over to page 12. There are disputes about the relevant period, and Mr. Ashton has taken 4 different periods. Dr. Cowley has taken a slightly different approach. Over to page 13. There's an identification of the base periods and the end periods. So again, slight differences in the manner in which these calculations have been approached. Over to page 16. Issue 5A, the source of the financial information. Now, each of the experts has relied on slightly different sources. Dr. Cowley, broadly speaking, has preferred to rely on documents which specifically disclose EBITDA data, whereas Mr. Ashton has decanted the EBITDA from the financial statements. So there's a dispute about which of those methodologies is more reliable. Over to page 18. treatment of financial information in the calculations. So there's a dispute, there's some differences between the experts on precisely how it is that those calculations are carried out. Over to page 19, we then have the differences between the experts as regards the end results. And over to page 20, that's for different periods. 21, page issue 6D, there's a discussion about measurement of growth by reference to certain other metrics. Over to page 22, a discussion of the impact of external factors, so what sort of things should be left out of account. And so Your Honour has a very detailed and considered document produced by the two experts appointed by the respective parties to explore this quantification issue that sets out the nature of and the extent of the disagreement between them. So it's quite wrong to suggest that the claimant doesn't have anyone to address this question. They do. Now, so that's the third point. The fourth point is that it has been suggested that the delay in producing this report is because it was not apparent until some correspondence in June, July 2025 that the report would be necessary. Now, I've already addressed that in part by reference to the fact that it was apparent from a very early stage that the companies were appointing an accountant expert. But here, my learned friend says, well, what we didn't know was that there weren't going to be management accounts. And it was only in July 2025 that we finally realized that we weren't going to have management accounts. And without those, we suddenly realized we needed a forensic accountant expert. And again, Your Honour, I'm afraid that misunderstands the background quite badly. And again, I do not criticise Mr. Hill because he wasn't involved, but I need to show Your Honour how this unfolded, and starting with the disclosure. So if we bring up F/3, this is the defendant's objections to the claimant's request to produce from over a year ago on the 27th of September 2024. And it sets out the requests that the defendants have agreed to produce, those that they've objected to, and those where they've made a compromise suggestion. And the relevant one for this purpose is on page 19 of this document. And it's request 13. And Your Honour may remember this, that there was a request from the claimant for a very long shopping list of financial documents. And one sees that in the left-hand column. And we don't need to read them all, but just to get a sense of the scale, if we go over the page, we see that the enumerated documents that they were asking for are extensive. But I would observe that what they do not include anywhere is management accounts. Now, if we just go back to the previous page, we see what the defendants, the then defendants, now the Liberty defendants, said in response. They said that was not reasonable or proportionate, but what we will search for is reasonably available records of the revenue of the business units within a particular time period. Now, the claimant was, even at the time, not satisfied with that, and he applied to Your Honour for an order that the defendants comply with his original request. We see that if we bring up G/26, Your Honour may remember this document. At the hearing in January 2025, the claimant made an application for disclosure in various categories and produced a table that set out the original request, the objections, and the compromise request. So we see, for example, if we go over to page 3 I'm afraid the text is quite small. If we just zoom in on the top of the page, a little bit more perhaps, we can see the structure of this document is that the claimant is seeking the text in red. And the relevant one for our purposes is at page 7. At the very bottom of that page, just go down the bottom of the page, please, and zoom in down the bottom. It's request 13, which is the same request we saw before. And on the left-hand side in the column original request, Your Honour sees the same shopping list that we saw in the original request to produce. If we just go over the page, we see that. We zoom in a little bit, but one can get a sense just from the scale. That's the same shopping list that we saw a moment ago. And if we just go back to the previous page and zoom in on the bottom right-hand corner, we see second from the right what the claimant was asking Your Honour to order, and it's that the claimant's original request is repeated. So the claimant wasn't satisfied with reasonably available records of the revenue of the relevant business units as we had offered. He applied to Your Honour for relief, and Your Honour refused to make that order. And we see that at C18. This is the order of the 17th of January 2025. We saw this a moment ago for a different purpose. But if we go over to page 3, at the bottom of that page, if we zoom in, we see except insofar as dealt with in other parts of this order, compromise request 13 is dismissed with liberty to apply. And where Your Honour is ordering except insofar as dealt with in other parts of this order, we see, for example, over the page, paragraph 2A, there's an order for audited financial statements of Liberty DMCC. But then particularly at paragraph 3A, there's an order for financial documents, the financial documents to be disclosed, provided that the confidentiality ring is established. And so the claimant sought to expand upon the disclosure. That was rejected. Liberty to apply was granted, and that liberty was never exercised. And so it can have come as no surprise to the claimant that the management EBITDA information that they later sought was not disclosed, because it was not sought, it was not ordered, and even when the application was made, management accounts were not amongst the shopping list that the claimant requested. Now, nevertheless, the claimant, although he did not apply, did write to ask questions about the financial documents that had been disclosed. We see that at K502. This letter is sent after the disclosure is given. So the claimant has already seen the financial documents that they're going to have. We see at paragraph 2, the claimant says it's critical for the parties' experts' reports that the individual EBITDA performance statistics for each of the business units are disclosed. Your client has done this for each of Ostrava, Galati, and Skopje. So pausing there, the claimant is content with the European business units. However, your clients have not produced documents which demonstrate EBITDA performance statistics for the Australian business units. So their complaint at this stage is not that the nature of the data that's been produced is inadequate, it's that it's not separate in the case of the 3 Australian business units, but has been presented collectively. Now, there's a line of correspondence on this. We don't need to go through all of it, but we ultimately receive a letter which is at K/511. There's a further letter from KBH on the 29th of January 2025. In paragraph 2, we see the same request being repeated. It's critical for a client's expert that the individual EBITDA performance statistics for each business unit are disclosed. There's then a series of granular questions about the certain documents that have been disclosed. And over to page 2, at paragraph 4A, there's a request to produce the individual EBITDA breakdown of certain units. Now, the Liberty defendants, shortly after this letter, gave their document production statement, which is at F/6. We're now on the 3rd of February, 2025. And if we go over to page 4, at paragraph 4.7, Liberty defendants are here listing the categories of documents for which they have searched. And the answer is reasonably available records of the revenue of the business units within that time period. We've seen that before. That's been the case ever since October of the previous year. And then at page 14, we don't need to go through the detail of all of this, but there's a heading D3 about that reformulated request. And we see beneath that in some detail, it continues over the page, an explanation of the searches that have been done, where the documents have been retrieved from, and how. So at this point, on the 3rd of February 2025, which is over 8 months ago, the claimant knows exactly what searches have been done. He knows what documents are available. He has liberty to apply pursuant to Your Honour's order, but he never does so. And instead, Dr. Cowley's report, I should add, he also has Mr. Ashton's report, which is served on the 3rd of February 2025. And the day after Mr. Ashton's report is served, Mr. Swangard gives a witness statement, as I alluded to earlier, explaining that it's really a matter for the claimant whether he wishes to read it or not. Just getting the reference for that. It's G50. And if we go over to page 5, so this is a witness statement given on the 4th of February 2025, so the day after Mr. Ashton's report is served. And at paragraph 17 at the bottom of that page, we see the claimant's legal representative indicate that to avoid any suggestion of an imbalance, we've refrained from accessing the link. And the reason for that was the claimant wasn't at the time ready to serve his evidence in accordance with the deadline and subsequently had to apply for relief from sanctions. But here we have the companies unequivocally saying they've chosen not to read the evidence served on them. The defendants don't consider that's necessary or appropriate. It's a matter for the claimant and his legal representatives whether to do so. So the claimant has had liberty to apply, clarity on the documents, and the expert report for over a month before Dr. Cowley proceeds to address the quantification issue. So, Your Honour, it comes as some surprise to us when several months later we receive a letter from KBH asking questions about these documents. And we see that letter at K/828. We're now on the 25th of June, so 2.5 months after expert reports and a very considerable time after disclosure and all the orders we've seen have been given. We see at paragraph 2, it's now said that as a result of discussions between Mr. Ashton and Dr. Cowley, Dr. Cowley has requested sight of certain documents. Given the need for the experts to agree a joint memorandum, we request that they be provided. Now, two things about this. First of all, it's Dr. Cowley who's requesting them, not some new expert. Second, it's being requested in order for the joint memorandum to be done, but still there's no application. If we go over to the response to this from Davidson & Co, it's at K851. And in paragraph 3, Davidson & Co straightforwardly confirm the management accounts are not in their possession. But Your Honour, the fact of the matter is, they weren't ordered, they weren't sought, the claimant knew that they hadn't been provided and there'd never been an application. So I'm not sure why on earth the claimant thought that there was suddenly going to be more documents produced after expert reports had been served. Now, we're told that immediately after this, the claimant runs off to instruct an accounting expert. We see that in Mr. Singh's evidence. That's at G/209. If we go over to page 4 of this document, given paragraph 10, given the first and second defendants had confirmed that no further financial information would be required, the claimant took the view at this stage that the court would be assisted by another expert. Further down that paragraph, the claimant therefore took steps to instruct an accounting expert. Well, Your Honour, that is completely unsatisfactory. The claimant knew full well what the position was many months earlier. If a new expert was to be added, it ought to have been added in good time for the existing deadline. But Your Honour, even then, even at that stage, there's no justification for the way that the claimant has proceeded, because if there was going to be a new expert added after the expert reports had been done and while the joint memorandum was being coordinated, then permission ought to have been sought from Your Honour promptly. But it wasn't sought promptly. It wasn't sought at all. Instead, a vague mention of it was made at the joinder hearing in passing. Your Honour rightly commented that if such a course was going to be taken, it needed to be done quickly. But permission was still not sought, and 2.5 months were allowed to slip by until the report was produced as a fait accompli. Malone and Friend says, well, we made the application as soon as the report was good and ready. But Your Honour, that's not good enough. It should have been done many, many months ago, and the claimant ought to have been contrite and seeking permission as soon as it became apparent that he wished to take a different course, no doubt in the light of new legal advice. So that's the delay. There's no good explanation for it. As to the interests of justice generally, we are now 2 weeks from trial. The Liberty defendant's skeleton argument is due in 12 days. There is an enormous amount of work to be done. It would be very unfair for the defendants now to be distracted by considering yet another expert report and having to prepare for the cross-examination of another expert. There is no time for a joint memorandum, and there is no time in the 10-day trial window for another expert.
Well, you say that, then I haven't seen an up-to-date schedule of witnesses. How am I to judge that?
Well, Your Honour knows that there is going to be 2 witnesses on the claimant's side. The claimant has served 100 pages of witness evidence. There's a very substantial amount of issues that we need to discuss with him. On our side, there will be 6 witnesses subject to the remote evidence application onto which we need to come.
Yeah.
And there will be 3 experts. The agreed trial timetable at the PTR.
3 experts, including this one we're talking about.
No, Your Honour. The 2 experts that the claimant has served evidence from and Dr. Cowley. Yeah. Because as has been apparent I'm sorry, I have that the wrong way around. Dr. Cowley for the claimant and the 2 experts for the defendants. Need to make clear there's no overlap between the 2 experts for the companies, because as was clear to the claimant from a very early stage, the companies have instructed one expert to deal with the market practice issues and another expert to deal with the quantification.
Okay.
Now, the final point is about the substance of the proposed report, because it's suggested, well, this is all just very simple and he can just slot in, no real prejudice will be done. But that's not the case. And I need to show Your Honour that report. It's at G/210 in the exhibit to Mr. Singh's witness statement.
Mm-hmm.
We start on page 7. We see under part 2, entitled The 2 Expert Reports I Addressed. And this section of Mr. Lazarevich's report, I apologise to him if I'm mispronouncing that, effectively provides a commentary of his views on the 2 existing experts. Quite a lot of it is argument made by the expert as a sort of super expert, adjudicating on the differences of opinion. So, for example, over on page 8, paragraph 2.2.4, we have Mr. Lazarevich expressing a view about the relative experience of the 2 experts. Paragraph 2.2.4, unlike Dr. Cowley, Mr. Ashton does not have an intimate knowledge of the nature and purpose of long-term incentive plans. He admits the limitations in his data, and so on and so forth. There's various statements to that effect in this section. If we go over to page 10, there's then a section entitled Difference in the Evidence Between the 2 Experts. And here we have Mr. Lazarevich making submissions about the documents on which each expert has based their respective opinions. And Your Honour's already seen that this very issue has already been the subject of a joint memorandum between Mr. Ashton and Dr. Cowley, and they've set out each themselves the basis on which they consider the documents to which they had regard were the right ones. But here we have Mr. Lazarevich piling in with his own view. And so we see, for example, 2.4.1, Dr. Cowley's list of documents show that he didn't receive financial data on particular business units. Your Honour will recall from the correspondence we saw a moment ago, those are precisely the 3 business units that the claimant said actually in correspondence they were satisfied with the data that had been provided. 2.4.2, we have an allegation that it's surprising that certain documents were not provided to Mr. Ashton, and a suggestion that their absence is a weakness in his analysis. We go over the page 2.5.1. We have an argument now that the fact that Mr. Ashton, we just zoom in on 2.5.1 at the top of the page, please. Here we have Mr. Lazarevich making a submission that the fact that Mr. Ashton based his report on financial statements is, he says at the bottom of that paragraph, an important shortcoming when attempting to analyse growth. So there's a question about whether Mr. Ashton's source of documents is reliable or not. 2.5.2, there's a statement of Mr. Lazarevich's experience. He suggests that businesses of this sophistication would have produced monthly accounts. So there's an assertion of standard practice based on his experience in support of an assertion of fact about the existence or otherwise of these documents. Something else that needs to be investigated, the subject of evidence and cross-examination. 2.5.3 an argument about what the most reliable data set is. That continues down to 2.5.5. Then 2.6, we've got Mr. Lazarevich setting out his opinions about EBITDA, legal EBITDA and managerial EBITDA. And the difference between those two things, again, something that's been discussed by the existing experts in the joint memorandum. And a suggestion that legal EBITDA, we go over the page to 2.6.4. A slightly perplexing statement that while it will be a matter for further evidence, we're not quite sure on our side of the courtroom what further evidence Mr. Lazarevich has in mind. But if my understanding is correct, it would imply that the audited financial statements used for Mr. Ashton's review are more likely to reflect legal EBITDA figures. So I'm not sure if the expectation is that now the companies are going to go and adduce further evidence to address this inference that Mr. Lazarevich wishes to draw. And then at paragraph 2.7, we have various partisan commentaries on the evidence. Mr. Lazarevich at 2.7.2 takes a view about the evidence in the case. So it's noteworthy that in his second witness statement, Mr. Gupta guessed that the metric could be based on EBITDA. And then over at next paragraph 2.7.3, we have Mr. Lazarevich, back on the previous page, please, praising Dr. Cowley for his wealth of experience. And Your Honour, it goes on like this. And so there are various points that would need to be explored through further evidence or cross-examination. There are issues that would need to be discussed with Mr. Ashton in a joint memorandum that's specifically for this purpose. But there is a final point, and that is that, well, then I should say that there's then vastly more evidence that goes to the quantification. So we see that at 14, paragraph page 14. Where Mr. Lazarevich redoes the calculations of growth. So we see under 3.2, we have Galati over the page. We've got more tables arriving at different figures to the other two experts. Not entirely clear what the genesis of all of this is, but it's clearly something that would have to be explored, analysed by the legal team, and the subject of discussion with Mr. Ashton and cross-examination at trial. This continues over several pages, so we see page 16, more calculations.
Can you give me a second?
Yes.
I just got to check my phone's battery. Okay, sorry about that.
Not at all. So those calculations continue over some pages, and there's lots of figures and details and explanations of how it is that it arrives at these things, all of which are going to require some considerable analysis. And we then arrive finally at the conclusion over at page 18, where we have the summary. And the last point about this expert report concerns its conclusions. If we go over to page 19 of 3.3.5, and the conclusions that Mr. Lazarevich reaches, and this may be the real reason why this expert report is being produced. We see what those conclusions are. First, if the claimant was required to meet 100% annualized EBITDA at any point during the 3-year period, he thinks that's been met. Second, if he was required to meet an implied growth rate of 100% in each of the 3 years, that has been met for years 1 and 2. And third, if the claimant was required to generate 100% EBITDA growth over the 3 years, looking at the average growth rate over those 3 years and comparing it with a base period, that has been met. Now, Your Honour, the reason I highlight this is that the first of those three is the claimant's pleaded case. The second and third are not pleaded and have not been addressed by Mr. Ashton. And to make that good, if we bring up perhaps alongside this, if we can, on Opus A/10, this is the the claimant's response to the defendant's request for further information. Your Honour may recall this was served shortly before the October 2024 CMC, and the claimant agreed to respond to it. In particular, I'm interested in the response at page 9 of this document. And Your Honour sees under 37.5.2 and 37.5.3, so this is the claimant's pleading, where he says growth would fall to be assessed over a 3-year period and the entitlement would crystallise at the end of a 3-year period. And we asked, what do you mean by that? You see the request at the bottom of the page. And if we go over the page, 7.1, do you mean that you would have become entitled to it if you'd remained employed after 3 years? We've seen that's the question that Dr. Cowley addresses. 7.2, was it to be assessed on an average basis over the period or something else? There's then a long paragraph 6 which complains that we're not entitled to the information, but the information is then given over on page 11. We just zoom in on the top of that page, we see the two ways in which the claimant puts his case and the basis on which the defendants are preparing for trial. The claimant's primary case is that LTIP was performance-based, with the entitlement accruing based on the agreed-upon metrics during the 3-year period, and did not impose a requirement that the claimant remain employed. So his primary case is that so long as he hits that target at any point during the 3-year period, there's no requirement that he still be there at the end of the 3 years. That's the first issue on the left-hand side of the screen that Mr. Lazarevich addresses. And then back in 7.1, at the end of that paragraph, if contrary to the claimant's primary case, to the extent that there was any requirement that the claimant remain employed for the full 3 years, that issue, of course, being the subject of separate market practice evidence, then the claimant's case is that but for his unlawful termination, he would have remained employed for a minimum term of 3 years. And although it's not expressly stated, we assume he means he would have met the target during those 3 years. And again, we've seen that that is the question which Dr. Cowley answers in his report. But what is not pleaded is the second two conclusions, some new way of putting the vesting case, which has never been pleaded, never advanced, and therefore not the basis on which the companies are preparing for trial. And so what we have here is an attempt to squeeze in a new way of advancing the claimant's case by way of a late supplemental expert report that should have been served many months ago for no good reason at all. And so, Your Honour, when you take all of those things together, this is a clear case where the claimant should not be allowed at the 11th hour to introduce this new expert report. There's no good reason for it. It will cause prejudice, and there's been no proper explanation. I'm told, Your Honour, that the Opus people would like a break.
All right. Very well. How long would they like?
It's usually 10 or 15 minutes, but
no, it's usually 5 or 10 minutes. So,
Oh,
So
Mr. Hill's less generous than I am, but
No.
I'm content with either.
Let's make 10 minutes to 12:45 UK time.
I'm grateful.
Thank you, Your Honour.
It's about 10 minutes. And if they're a minute too late, it doesn't matter. Right. Thank you.
Thank you.
Is anyone else back apart from Mr. Trotter?
I'm sorry to disappoint, Your Honour.
Mr. Baradon and Mr. Hill. You finished, Mr. Trotter, have you?
I am.
Yeah. Mr. Baradon, do you want to join in this discussion?
I'm not in a position to, no. Thank you.
Thank you. Mr. Hill, do you want to say anything?
Your Honour, yes. I do accept that the wider wording of that subsequent order, which I wasn't aware of, I have to say, does adjust the position. So I do withdraw some of the submissions I made. Although, to be fair, I always made clear that I wasn't in any way seeking to exclude Mr. Ashton's evidence. It's simply a point of achieving equality. Despite all my learned friend submissions, there are 4 points that stand out. First, the court and the parties do not have the ordinary managerial information, monthly management accounting information that would enable the exercise to be conducted in the normal way. And despite everything learned friend says, that didn't in fact become fully clear to us until July. In that context, my learned friend referred to the disclosure process that led to the July correspondence. But in my submission, that was really a point against him. What it showed was we had asked for monthly performance reports from an early stage. That was resisted, amongst other things, on the grounds of proportionality, which we can now see, now that the issues are crystallised in the experts' reports, how unreasonable it was for the defendants to resist that request in the first place on those grounds. It's fair to say the court did refuse our request at that stage, but with liberty to apply. And thereafter, we, as the learned friend showed you, we have been engaged repeatedly in correspondence in relation to this sort of material, culminating in the further request that led to the final refusal in July. And it was right for us to engage in correspondence against the background of a liberty to apply. And the fact that we didn't.
But there never was an application.
There wasn't an application, but we were told in that final correspondence it wasn't within their control.
Right.
So we were where we were in July. And so once we got to July, that was the end of the road, as it were. And then we had to do what we could based on the information available. So that's the first point, that the court doesn't have it. And secondly, what that means is the court at trial has to do the best it can with a hodgepodge of different financial information. And thirdly, that means that in that context, an accounting expert does become more necessary than it otherwise would, or at least it will particularly assist the court. And that takes me to my fourth point, which is that in that context, there is now a significant inequality because the court does have the evidence of one side's accountant and it has no answer, and the court won't be assisted, absent Mr. Lazarevich's evidence, in evaluating the evidence given by Mr. Ashton. My learned friend says at a very high level that this topic is traversed by both experts, but his submission misses the point. Mr. Cowley, yes, he does address whether he considers the LTIP is met, but he's not an accountant. What he does not do is embark on Mr. Ashton's exercise of trying to extrapolate the statutory information to draw conclusions on what the EBITDA level is. He's not an accountant, he can't do that, he can't make adjustments of that sort, and he doesn't try to. What he instead does is a different exercise of taking the very limited managerial information that is available and saying on the basis of that limited information whether he considers the LTIP trigger was met. So in a sense, you've got ships passing in the night. You've got Mr. Cowley doing the best he can with limited management information available. And then you have Mr. Ashton, who's conducted a wholesale exercise of estimation and adjustment of statutory figures, where he draws his own conclusions on the LTIP. And at trial, you're going to be in a very difficult position, in my submission, in evaluating what Mr. Ashton has done without the answer to it that Mr. Lazarevic gives. And
what troubled me when Mr. Trotter was taking me to Mr. Lazarevic's report was the very long section at before he got down to his accountancy points of commenting on other witnesses.
Well,
it didn't seem to me that was really A, his role, and B, very helpful for the court. The court will hear that sort of thing in cross-examination.
Well, it's fair to say my own friend did cherry pick some paragraphs of Mr. Lazarevic's evidence. I don't know if you've read the whole report.
Quite a full bunch of cherries.
Well, no, not all of those points are fairly making my learned friend's point. So, for instance, Mr. Lazarevic, in some of the passages you were taken to, made observations about the information that's available and has been relied on by each expert. That's useful. It's useful to have it.
Yeah. That's useful, but stuff about how Mr. Ashton is less experienced or more experienced and that sort of thing, it doesn't help the court at all.
No, but there may be fair criticism there. I'm not going to try and defend every paragraph, but
the trouble is, Mr. Hill, it leads to a difficulty that both the court has and the counsel for the other parties have of knowing what they have to cross-examine on. And it could have been a much shorter report of, I'm guessing, about 3 or 4 or 5 pages.
Well, it isn't particularly long, and it doesn't take time to get to grips with it. The critical passage is section 3, where he does the EBITDA calculations, which are responsive to Mr. Ashton. Section 2, we accept, is more background commentary. And I dare say, I mean, if we had to, we could probably live without section 2. We'd better see if there are cross references that would need to be taken out.
What I would be minded to do is this, because I think an important point you make is that the court should have the best information available to it. But what I don't think is permissible is to have a second expert giving a commentary on the other experts at this late stage. And with that in mind, I would suggest that I will allow the report in with this proviso that in the next few days, your team, I don't mean you necessarily personally, but your legal team, go through that report carefully, put your line through that which is commentary on other people's reports, and limiting it so far as possible to the precise accountancy point that you're trying that Mr. Lazarevic is wanting to make. Now, yes. I'm not going to do that myself.
No, we will do. And just to be clear, obviously he is answering Mr. Ashton, so he will refer to Mr. Ashton's evidence, but we will avoid things that look like unnecessary commentary and submission rather than grappling with the actual evidence.
I'm persuaded that if that is done, the month to 3 weeks or so or more till the experts come on should be time enough to take into account cross-examination of his points. There'll need to be some adjustment to the timetable, and I'm sure there'll be many other factors leading to adjustments to the timetable. But Mr. Trotter, I'm going to ask Mr. Hill's team to submit this to you by, say, close of business Tuesday, Mr. Hill?
Yes, that's fine. Yes.
A copy of the report with lines through, I hope, fairly substantial chunks of it, limiting it to a point. If you want Mr. Ashton to respond to it, and I'm not encouraging that, but if you want Mr. Ashton to respond to it on the narrow additional points, I'm going to allow that in principle. Mr. Hill, you don't object?
No, I don't object.
And that can be done before trial. I don't think this need affect skeleton arguments, because skeleton arguments can always say it can leave a gap for the accountancy expert and followed up later for written final submissions.
Yes, I'm content with all of that.
Mr. Trotter, do you want to build in? I don't think I need to build into an order your right to come back on things with a further report if necessary, but you can take it that provided there's no unreasonable, provided we're not faced with an equivalent report on your side, that there'll be no objection to a proper focused reply if such is thought desirable.
That's well understood and heard, Your Honour. I'm afraid I'm not in a position to confirm when that could be done. Mr. Ashton's a busy professional who I do not know what his commitments are, and it's very likely that there will be some difficulty in engaging with him and obtaining what is necessary. So we will do it as soon as possible, but in the circumstances and given the lateness of the report from the claimant, we can't really be held to a tight timetable.
That's understood. But remember, the experts won't be on till later in the second week, and I think with the 2 weeks before the trial and into the second week of the trial, there should be time enough.
Yes, thank you, Rod. I should just put down a marker on one thing, is that I made some submissions about the fact that certain of the conclusions in Mr. Lazarevich's report are not pleaded by the claimant, and I don't take Your Honour to be making any determination about whether it's open to the claimant to advance that case at trial.
If and when an application is made one way or the other, I'll have to deal with it, but nothing at the moment requires my determination on that, I think.
I think the next topic might be skeletons for trial, which is a very short one. There are just two.
Skeletons for trial, but I think, don't we need to look at the what's called the second defendant strikeout immediate judgment application?
Yes, happy to take that.
I wonder, Mr. Trotter, this is your application. Having read very quickly the reasons given by the Chief Justice, it becomes slightly less of a clear-cut issue. In that he doesn't say I'm right about relation back, or he doesn't say I'm wrong about it. He says it's all very interesting.
Well, one can hardly deny it's all very interesting. But to the contrary, Your Honour, our position is that it makes the position crystal clear, because what His Honour the Chief Justice says in terms at paragraph 32 is that Mr. Kahlon has unequivocally nailed his colours to the mast on the relation back issue
against Mr. Gupta. That's the point.
Well, I'm not sure if Mr. Hill is going to suggest that it's open to him now to change his position in the same proceedings against other defendants, especially against other defendants that the claimant has maintained all along should in effect be treated as the same, and has advanced various positions on case management, the jurisdiction challenge, full and frank disclosure, and so on, all on that basis.
Yeah.
But if that is, we'll need to hear from Mr. Hill about whether that position is seriously going to be taken. But if it is, it's another reason why this needs to be determined promptly.
Looking at it realistically, if you had an application of that sort, it would take a day between now and the trial. There would then be the possibility of an appeal. And that appeal would simply delay matters to divert people's attention from preparation.
Well, Your Honour, much depends on whether the claimant is now opportunistically going to take the position, changing his position for a second time, that there is in fact adoption of relation back. And in my submission, that would be utterly hopeless at this level, not least because there are now two judges of coordinate jurisdiction, Your Honour and the previous decision of Abdul Salam, who has found that there is no such doctrine. So any argument of that kind is only realistically available to Mr. Kahlon on appeal.
Yeah, okay.
Now, the difficulty
that being the case, there's still the dissection of the pleadings to see what would be covered by your strikeout application.
Sorry, Your Honour.
The response to your application, I think, on another level, is simply to say, well, it's not time barred under, I can't remember now whether it's UAE law or DIFC law,
Yes, yes, you're right. And it's that response that is generating significant procedural turmoil, because it's what the claimant hasn't really done in his responses so far is defend his claims under the UAE Civil Code. There's been no suggestion, at least under sections 897 and the provisions in the 900s. It's not suggested that those claims are not time barred.
I might be able to cut
Instead,
through.
it's
Sorry, apologize for interrupting, but I think I can probably cut through this. We, in light of the Court of Appeal judgment, we will not be trying to run inconsistent horses on relation back.
Sorry, I didn't hear that. You will not be what?
We're not going to be trying to run inconsistent horses. We are not going to say there is relation back in the face of the judgment and the Court of Appeal. That does mean that, but that doesn't mean Malone and Friends' application for immediate judgment succeeds by any means at all. Most, if not most, of the central claims, the main claims, remain in the case. We are due to serve evidence on the application on Monday. When we serve evidence on Monday, we will make clear those actually very limited parts of the pleading which will now fall away if we're not running relation back. That disposes of my learned friend's concern, but he doesn't know which parts should still remain in the case. We'll make that clear when we serve evidence on Monday. And there's no basis for immediate judgment, and that would be, as Your Honour says, a long, difficult, contested application to even attempt to go down that route.
Well, Your Honour, that is a very helpful indication that it will now be common ground, as between the claimant and the companies in these proceedings at least, that there is no doctrine of relation back. Now, it will follow from that, I take it, that the relevant parts of paragraphs 16.2 and 16.3 of the reply, which rely on that doctrine, will now fall away. I assume it will also follow.
Sorry, just to interrupt you, Mr. Hill was nodding. I just want to make sure I saw correctly.
Yes, those passages of the reply fall away, but also I think that in anticipation of what my learned friend's about to make, we accept that there are certain parts of the particulars of claim that we are not now pursuing at trial. But that doesn't for a moment mean that there's anything close to an entitlement to immediate judgment.
Well, that is a helpful indication, but it does not quite resolve the issues that have arisen as a result of the claimant's response in correspondence to the strikeout application. And I need to explain why that is, because the issue is not just about which parts of the pleadings are going to be removed. There's a dispute about whether the claimant can now run various additional points which we say are not pleaded, and which the claimant, Mr. Hill, will not agree with me on that. But it leaves significant uncertainty about the state of the pleadings in important respects. And there are three of them. I'll list them first.
Well, just before we go, I don't want to get involved today on a strikeout application. We haven't got time for it. But the other thing that in the back of my mind is this: you've known about Justice Sir Jeremy Cook's decision in whatever case it was about no strikeout and no relation back, and yet this point is only now being raised for the first time a matter of a week or two ago. Why is that? Well,
Your Honour, the decision of Justice Sir Jeremy Cook in that case, without any disrespect to his honour, did not consider the sorts of arguments that were being put forward on the jurisdiction challenge. And so the point had been considered in passing, but certainly not authoritatively resolved. Your Honour now has considered those arguments and has reached a reasoned conclusion, and permission to appeal has been dismissed. Now, whatever the rights and wrongs of that history, the position presently, and I completely understand that there may not be time today to resolve the strikeout application. It's helpful that we've had an indication that certain parts of the pleading will be removed. My concern, from a practical perspective, is that what we do not yet have is a resolution of the dispute that has emerged about whether the claimant is going to be entitled to advance certain unpleaded cases that he says he wishes to advance. And that arises on the immediate judgment application because we say that none of that is pleaded and that the entire case against Liberty DMCC should be struck out. And my learned friends...
Isn't the better course, though, to get Mr. Hill's letter on Monday, is it?
His evidence on Monday.
His evidence on Monday, and any accompanying letter identifying what is or is not being pursued. You then go back to your clients, go back to him on the basis of identifying particular things that remain in doubt in your minds, and ask for an answer and get an answer by. This can be done each by a daily return letter, and then you know whether there's anything that needs debating.
We're content.
Your Honor, the difficulty is that Mr. Hill's evidence will not resolve, unless he says otherwise, the question of whether the claimant intends to run a DIFC law case against Liberty DMCC. Now, that's been maintained by the claimant in correspondence repeatedly since we sought expedition of that application. I don't expect Mr. Hill is going to change his position on that now, and I don't expect that the claimant will change his position on it in the evidence on Monday.
To be clear, that's our primary case, and it's always been our primary case.
Well, that is precisely the issue in dispute, because Mr. Hill says, well, this has been pleaded all along. But, Your Honour, that, I'm afraid, is not the case. And when I take Your Honour through the pleadings, it will be clear that no such case has ever been pleaded. And this is a last-minute pivot in response to the Liberty DMCC's application to run an entirely new case under DIFC law against Liberty DMCC at trial. Now, Mr. Hill will dispute that, but Mr. Hill will dispute that, but the practical difficulty to which it gives rise is that as matters stand, we do not know whether he will be permitted to run that case at trial. Therefore, we do not know whether Liberty DMCC needs to plead back to it. Never mind the difficulties of pleading back to a case that one has to squint very hard at the pleadings to discern quite where it is. And so it's that dispute which has crystallised through the immediate judgment application on which we need your lordship's assistance, because otherwise, in the coming weeks, there are going to be more unhelpful skirmishes about whether or not this case exists. Liberty DMCC is then put in a position where it needs to make some sort of contingent application to amend in case the pleading point is dismissed at trial. And there's then going to be an unhelpful and unruly debate on the first day of trial about what Mr. Hill is and is not allowed to argue. And this has practical significance because one of the responses of Liberty DMCC to this new DIFC law case is to say that the claims under that law are time barred as well. And we don't, and so if my learned friend amends, or if your lordship, if your honour finds that he's entitled on the existing pleading to advance a DIFC law case, then Liberty DMCC will need to amend to plead that limitation defence. And we don't yet know what it is that Mr. Hill will say in reply. We do not know whether what he says in reply will raise further issues of law, whether there'll be some question about when knowledge was obtained, and so on and so forth. And none of this can crystallise until we have a resolution of the question of whether Mr. Hill has pleaded this as he says, or this is a new point being raised in response to the immediate judgment application. Now, that is a question which can be resolved today because it's a straightforward question of reading the pleadings, and which would, and we don't, for our part, really understand why it is that the claimant is resistant to that. It would assist everyone to know what the position is, and it can be done easily and quickly.
Well, that's just one.
How long would that take?
I think it would take over half a day.
All I need to do is to take your honour through the particulars of claim.
Well, I'll tell you what. Can you do that within 5 minutes? And then Mr. Hill can think about it and come back later, either in writing or whatever.
Well, I certainly end up.
Or can I just make an alternative suggestion, which is that we do say this claim has always been in the pleading, and he should have already pleaded everything he wants to plead to it. We're not clear what realistically they would want to plead further, but we don't have a problem with them putting in a further plea, and they can do it without prejudice to their position that our claim isn't properly pleaded. So they can get in as a matter of pleading their limitation point or whatever it is in the next few days. And then the points will be out there. And then the court at trial can determine the scope of the claim. Because there's no way that in a few minutes this point can be developed. We already know what the point is. It's been developed over pages in skeleton argument already, even by way of mention before you develop the application. So it's far too long a point to deal with, other than I suggest in the way that I put forward.
What about, Mr. Trotter, that idea of pleading your limitation defence without prejudice to whether it's pleaded against you or whatever?
Well, Your Honour, this is an elegant attempt to ram through the pleading point by the claimant to effectively avoid any scrutiny of the pleading and to proceed on the basis, whether right or wrong, that it's always been pleaded, and we should just plead back to whatever we can draw from the existing pleading on the basis that...
If it turns out at trial that it hasn't been pleaded, then it'll fail.
Well, Your Honour, it just adds to the burden of the various points that are going to have to be explored in opening and closing at trial. We're going to have potentially additional issues arising as a result of whatever plea we get in response to the limitation defence that will then all need to be explored in preparation for and in submissions at trial, none of which will be necessary if the claim is not pleaded at all. We say it's plain as day on the pleading that it's not there.
Well, then by all means put that in your skeleton argument. I'm not with you on this. I don't think it's helpful to have a further hearing, a further decision, leading to the potential for further appeals all the time. People saying they're up against it, preparing for trial in 2 weeks. It seems to me that these matters can be addressed by an amendment without prejudice if you want to make one, and otherwise dealt with in the skeleton arguments.
I'm grateful. I think the remaining issues are all extremely short now. So I think there's trial skeletons.
Yes, you all want 70 pages.
Yes. I think the first is...
I'm so sorry to interrupt, Mr. Hill. It's just one matter of administration, really, that I'm not sure whether Your Honour intended to lay down a timetable for those contingent amendments in relation to the DIFC law claim.
How long do you want?
I think it's in everyone's interest that this happens very quickly, because we need to know what Mr. Hill's going to say in reply. So I think we could put in our amendments by 4 p.m. on Monday, with Mr. Hill to reply by 4 p.m. on Tuesday.
Could we have at least till 4 p.m. on Wednesday? One day really is a bit much for a pleading response, but I mean, if we can do it by Tuesday, we will. But Wednesday is a stop.
Mr. Trotter, happy with that? You by 4 p.m. Monday, Mr. Hill by 4 p.m. Wednesday.
Yeah, I'm sure we can accommodate that.
Yeah. All the times, by the way, are Gulf time.
Yes.
Yes.
Mr. Paramjit, yes. You didn't want to come in on this point, did you?
For the reasons I've given, I'm unable to assist. I'm afraid.
I thought I should just give you the opportunity.
I'm grateful.
Yeah. Right. Back to skeletons.
Skeletons. So two aspects. First is timing. There's an existing direction for timing, which is sequential exchange, which I think is Monday and Wednesday. Given everything else going on,
Monday of the week before trial.
Yes, Monday the week before trial and Wednesday the week before trial. Given everything else going on, we would prefer if we reverted just to exchange of skeletons 2 clear days before trial, or if the court is minded to keep sequential, an extra day would help us. So Tuesday
Tuesday and Thursday.
and Wednesday. But we're in your court's hands on either of those. The court's hands on either of those alternatives.
Mr. Trotter, I think there was a reason, presumably, for having them sequential rather than exchange.
Yes,
I've got no idea what the reason was.
Yes, I think one of the reasons, at least, is it's not going to assist Your Honour to have two skeletons passing in the night, and the sequential exchange is going to be much more helpful. That's been the position since October last year, and there's no reason to change that now.
What about Tuesday and Thursday rather than Monday, Wednesday?
Tuesday and Thursday would put me personally in some considerable difficulty, Your Honour, because I'm in court on Wednesday and I'm flying to Dubai on Thursday. So that change to the timetable would mean that I have no time to look at the claimant's skeleton argument when it's served. The claimant is the one wanting to push this trial.
You're in court on the Wednesday?
Yes. In London. And so we'll, on my learned friend's proposal, we're going to have a skeleton served in the early afternoon on Tuesday, London time, and then have to reply to it in the early afternoon on Thursday. So I'll have the dying hours before a court hearing on another matter on Tuesday afternoon, in court on Wednesday, and then in travelling on Thursday. There'll be no time to respond to the skeleton argument if this new timetable is proposed. It's all been proposed for the first time, I think, in my learned friend's skeleton argument, served at about 5:30 a.m. British time this morning.
I think, Mr. Hill, I think the suggestion you make, although it might sound sensible, puts Mr. Trotter in difficulties. So I think we're going to have to stick to.
Fine. No, I understand his court problems.
So this is sorry. Your skeleton then on Monday 4 p.m. Is that right?
Yes, and theirs on Wednesday.
And theirs on Wednesday. Mr. Trotter's on Wednesday, and I should say Mr. Baradon's on Wednesday as well.
Yes. The second. Sorry.
I think Mr. Hill's about to come on to the length, so I'll let him develop his
Yes,
submission.
the second aspect is length. Two minor points. Someone's put down a marker that we should keep to a 12-point font. We will do that. Secondly, is something from our side. It's whether, given there's an existing direction for 70-page skeletons, there should really be two 70-page skeletons from the defendant. So they have 140 total. We submit that's not necessary, and also will lead to essentially duplication, because there's no way that Mr. Gupta needs 70 pages to deal with his narrow Gupta side issues. So all that we will end up with is either duplication or extension of common defendant positions over 140.
If I can say so, the limit is a limit, not a target.
That's right, but we know how these things usually pan out.
That's why I don't like 70 pages. It's much too long.
We would suggest that Mr. Gupta be limited to, we suggest 30. We're happy to play with the number a little, but certainly not up to 70, so that he can be focused on the Gupta side issues.
I'm not going to curtail Mr. Gupta at the moment. It seems to me, I'm sure properly advised, he will give a skeleton of the appropriate length to deal with the points against him. I can't second guess him on that. Do you really need 70 pages each, sir? Mr. Hill, do you really need 70 pages?
Well, I think I probably will. I mean, it's hard to say. I think I probably will. If we can, we'll keep it shorter. Can I just also...
From the position of the judge trying to read and digest, shorter is better.
I understand. Well, we will all bear that in mind. And also, I do bear in mind what Mr. Baradon said earlier, that in all of his conduct and litigation, he does need to try to avoid duplication, and we shouldn't be in a position of essentially facing common defendant side issues duplicated or ranged across both sets of defendants. They need to, only one of them should be dealing with particular points on common issues.
I hear what you say, and they hear what you say, and no doubt will be minded to take that into account.
Yes, so I should also lay down a marker on that, though. Of course, any advocate in performance of their duties, will endeavour to do that. The schema of what the claimant has proposed throughout all of the issues today is to railroad my client into not responding points that he can take. If I or my client's advisors think that D1, D2 have got something wrong as a matter of law or fact, we are entitled to and will advance that case. Further, there are a number of conflicts of interest between the positions of the corporate defendants and my client, albeit we may not have time to explore everything properly before trial, given the orders that have been made. We aren't able to fully exchange information on a common interest privilege basis because we're not in the common interest on many things. So the opportunities to limit will have to be viewed in that light. And I'm afraid we will do our best, but the best we'll have to do.
Well, everyone's put down their.
I accept that. Yeah.
Can we now move to trial timetable?
Yes.
There are 2 points here. First is the timetable itself. The defendants produced a revision to the timetable at paragraph 33 of their skeleton. Now, obviously, all these timetables are always provisional, but their proposed revision does look basically fine to us, subject to one adjustment.
Sorry, where is this?
This is 33 of Mr. Trotter's skeleton.
Page 10.
Page 10. Hang on one second.
So that does look basically fine as a provisional timetable, subject to one point, which is that time needs to be equally allocated for submissions and everything else between the claimants on the one hand and the defendants on the other hand. And if you look at, for example, at the time for closing submissions, it's not obvious that that's happened. And I just put down that marker as well. It is important that they don't get, if you like, 2 bites of a cherry time-wise compared to ours.
Well, Your Honour,
I think, if I can just say something, I think it's premature to make a ruling on that. We need to see what Mr. Gupta's position is, the way he conducts the case, and what points he takes, different or overlapping with the other defendants. I think we ought to address that a few days into the trial.
I'm happy, and I would just to foreshadow that even if he does take other points, I've still got to deal with them. So I've got to deal with both Mr. Gupta and the other defendants, and I will probably always need an equal amount of time to them collectively. So that's the first point, which I'm happy to leave. Second point is order of witnesses. We have, as you've seen from the skeletons, been pressing to have the order of witnesses. It's now very late not to have them. I've never been in a trial of this size and not had orders of witnesses voluntarily exchanged well before now. The learned friend says in his skeleton that we only asked them at the beginning of this week and they couldn't, it's very quick to turn that around. But they must have been thinking about this for weeks, if not months, and they must know what their order of witnesses is likely to be. So we do ask that get given to us today, if at all possible, because it's really starting to affect our preparation, not knowing what witness comes first. And we should also say that we very much hope that when we do get the order of witnesses, that Mr. Gupta is first on the list as a witness. I know this is to Mr. Trotter because he's Mr. Trotter's witness. He is the main event in this trial. He is the person who we say reached the agreements with Mr. Kahlon, and he's the person who made the decisions to dismiss Mr. Kahlon. It would be unfortunate if we saw game playing whereby he's shielded behind other witnesses, in particular the remote witness, where it's unsatisfactory, we're going to have a remote witness anyway. And the court is able, and quite often does, give a direction or at least an indication that it's helpful to have a particular main witness up first. And I would invite, if Mr. Trotter is not volunteering it, I would invite an indication of that kind. So that
I apologise for cutting across Mr. Trotter on that. Mr. Gupta is going to be my witness. I'm late to the party. I don't know what's going on. I'm going to have some input on that, or my team is going to have some input on that, and we're not in a position to do so, I'm afraid.
Well, that's very.
What I'd do is, I think Mr. Barradon's got to have some opportunity of finding out more about his case. What occurs to me is that to have a schedule of witnesses, simply saying C's witness, D's witness, and so on, doesn't help the court very much in preparation for what's coming up. Normally, you see the witness named and the precise estimated length of time that witness will take before moving on to the next witness, and so on. In other words, much more detail than is presently on the proposed timetable. What I would encourage parties to do in the next, it needn't be done today. Mr. Barradon is clearly not in a position to do it today. But if parties can work on this between themselves over the next few days and submit a revised and more detailed timetable by, say, Wednesday or Thursday of next week.
Can I suggest Wednesday at the latest, because it's really affecting our ability to prepare cross-examination, not knowing who's coming up first.
Wednesday next week, everyone happy with that?
The cynic might say it won't be possible to prepare cross-examination from Mr. Gupta until I've pleaded my case and we've seen their reply, but I'd have thought Thursday would allow plenty of time in those circumstances. It's still before my defence.
Well, I still press for Wednesday. We know what Mr. Gupta's said. We've had his evidence.
Well, any agreement on timetable can be varied by a subsequent agreement or by application to the court anyway. So let's aim for Wednesday, and if things change, they change.
Your Honor, I should say there's not going to be any procedural game playing or trying to shield any witness from anyone. This is all a matter of logistics, and we're making inquiries, as we've said, with our various witnesses who are on all sorts of different time zones. Some of them don't work for the Liberty defendants, and it's all contingent on what the trial timetable is, so what the window in which they'll all be called, and also the remote evidence application. Now, I took from Mr. Hill a moment ago that it doesn't sound like that's now going to be opposed, which is helpful and assists us in coordinating that witness's availability. But being asked a couple of days ago to give our lists and times for everyone is quite unreasonable. And Mr. Hill says we must have been considering this for months, but I'm afraid there has been a little bit to do, and Your Honour can be assured that we've not been sitting idle, but logistical arrangements for witnesses have perhaps been overtaken by other events.
Is it too much to hope, though, that by, say, Wednesday, parties should be in a position to have penciled in at least a running order and approximate times for witnesses?
Well,
I think certainly Mr. Gupta's point is perhaps a separate one and comes in later, but
yes,
a penciled-in timetable would be useful, which could be hardened up by a bit later in the week.
We will certainly endeavour to do that. While I've been making these submissions, I've been asking for instructions about the practicalities of all of this, and at the moment I can't commit to whether we'll be able to ascertain all of the witnesses' positions by then, but we will certainly do our best.
Well, the ones you can't, you can explain what the difficulty is and say what you hope to do with them.
Yeah.
Well, as I say, we'll do everything that we can as quickly as we can.
And when you're putting timing for individual witnesses, you have to remember that the transcribers will require a break every now and again of 10, 15 minutes. And often it's forgotten about when you're saying how many witnesses can get through the time.
Yes, Your Honour. I mean, on that point, it is a minor logistical issue, but I wondered if Your Honour might be in a position to confirm the sitting times, what time we'll be starting in the morning and finishing in the afternoon, for instance.
The time I sat when I was last out there was 10 in the morning till 1 and 2 till 4, but it can be changed if necessary. Is that what you had in mind?
That's certainly helpful, Your Honour, and the parties can probably take that away. For my own part, I think this trial is going to be quite jam-packed, and any further time we can squeeze anywhere will be of assistance to everyone, I would have thought. I see Mr. Hill nodding.
If you can liaise with the court, they might be able to make it 4:30 rather than 4 at the end of each day. It's partly court staff and partly transcribers and so on, but certainly I sat late 1 or 2 days for the last trial I did.
Thank you, Your Honour. That's a very helpful indication.
There's now just a couple of matters to mention. First is the remote evidence application. I don't want to go to the detail of that in open court for the reasons everyone knows. We've hardly had any time with it, but I can confirm that it's very, very likely that it won't be opposed. But the parties will need to agree on the protocol and logistics for how the evidence will be conducted remotely. And I should say the fact that there will be this remote witness does, in my submission, reinforce my point that it really is best for everyone and should happen that Mr. Gupta goes first. But I've left that to be taken away. There's then the costs of Mr. Gupta's jurisdiction application. I'm not sure anyone wants me to take up time on that today. What I wonder whether, I mean, I would hope my learned friend can confirm at least that he doesn't intend to oppose the costs in principle. And then the question of immediate assessment or interim payment is something the court might want to address on paper, or they might want to put in a sort of couple of pages of any points they would want to make to oppose it.
Mr. Barron, I think it's your territory.
Well, is it my territory? It wasn't my application at the time. My instruction is the trial's 2 weeks away. This can all be addressed at that time. There are points which require clarification in the new team's understanding in order to address it properly. On the face of it, it appears that many of the costs of the jurisdiction application may actually be costs of trial because they're costs that go to merits, but it's difficult to say very much at the moment because I know so little. So that's a long way of saying trial's only 2 weeks away. Given the difficulties that we have in making substantive submissions, the costs have been reserved to the trial judge, and we say that's the right order at present.
And just in answer to that, we say the court already has enough information to make the usual order on costs now, which is that we have all our costs on a standard basis, if not agreed, of both the appeal aspect and the first instance aspect, with questions of immediate assessment and or interim payment to be addressed on paper.
Although I think
apologize for speaking again, Your Honour. We're being asked to read in draft a defence, draft witness statement, RFIs, see new pleadings, see new expert evidence within the next 5 working days. The submission that in the same context it's just, or in the interest of justice or the overriding objective, for us to engage on the trivia of a costs order that can be addressed in 2 weeks' time is in my submission misplaced.
Well, my learned friend overlooks the point that my client is an individual, and of course it's in his interest to punt these costs into the long grass as much as possible. But the principle under which this court usually operates is that people pay as you go, and securing interim payment now is of significant importance to my client, rather than leaving it to trial when the court's going to have probably even less enthusiasm for addressing it than it does now.
Well, there's 2 aspects. One is incidence of costs, who's going to pay them, and for my part, I think the Chief Justice reserved them for the trial judge. Is that right?
Yes.
I can't see any potential objection to an order for costs against Mr. Gupta. What I'm prepared to do, though, is to, on that score, not make the order until say Wednesday of next week, to allow Mr. Gupta an opportunity of saying anything if he wants to say it. As regards assessment of costs, I'm prepared to make a summary assessment of costs, but not in that short timescale, because I think Mr. Gupta's team must be allowed to concentrate on what matters. sorry, I'm not saying costs don't matter, but the preparation for the trial, and what I would be minded to do would be to deal with this either at the first day of the trial or in writing the day or two beforehand. Best thing maybe if I dealt with assessment on the first day of the trial.
Yes, I'm grateful.
Not asking for any oral submissions on that, but simply any response to your schedule, which I'm not sure where it is, but I'll find it somewhere.
Yes. And then the final matter, which I think is again is only a mention, is the CRO.
Yeah.
There has been correspondence. Mr. Trotter's clients have put forward a proposal on the CRO that we think where it doesn't really work. It involves us having to not refer to the contents of documents while taking witnesses to them or making submissions about them. And then if we do, it involves the court sitting in private. All of that is something the court is unlikely, particularly sitting in private, unlikely to want to entertain at a trial. So we suggest the matter be left with the parties to try to take further and come up with better proposals. And we will counter propose something in correspondence, and hopefully something can be agreed that works.
Yes, and Mr. Gupta is presumably to be involved to the extent he wants to be involved in this. He will be copied in.
Yes. So
yes,
I think
it better be resolved before the trial starts. I suppose it needn't be. It can be resolved on the first morning.
it can be. I very much hope it will be resolved before the trial starts. In particular, if there's a point about sitting in private, because as everyone knows, that's quite a complicated point, and there's an awful lot of authority, and we really hope we're not going to get diverted into all of that.
I must say I would need some persuading to sit in private.
Yeah,
but I'm not saying it's impossible. But
I should say at the moment, I can't really imagine a situation where it's going to be necessary to sit in private. There's been a redesignation scheme that Your Honour ordered at the PTR. The companies have followed that. There's only 64 documents that have been redesignated as confidential. Most of them concern the remuneration of employees other than the claimant or private personal information relating to non-parties. There are only 2 documents which have been redesignated on which Mr. Ashton relies. And so the ambit of the confidential information is extremely narrow, and it seems to us that the point can perfectly well be dealt with insofar as any reference to these documents at trial is necessary at all by just referring the witness and the court to the document, which everyone will be perfectly able to see without reading out the particular text. Now, that problem may never even arise, but it may not be necessary to refer to these documents at all. But insofar as it is, it will only be a very small part of the trial, and it can be managed in that way. And my learned friend has had the highlighted documents that show the redesignated sections. They're all replaced on the Opus bundles. And there really ought to be a way through this that doesn't require some enormous application to sit in private.
Well, I've heard that, and I hope there is. But can I just say I'm not sure I accept Berger's characterisation of all of these documents as being matters of that are unlikely to be gone to anyway. But we can take this up outside.
I'll leave you all to talk about that yourselves. Is there anything else on the list?
No, not from the claimant side.
Mr. Trotter?
I'm just quickly looking through my list. No, Your Honour, I think we've covered everything.
Mr. Barron?
No, Your Honour, thank you to you, the court and the transcribers for sitting so late.
Yeah, well, I apologise for keeping you here so late, but things had to be gone through. Right, we will meet, hopefully not before, but we will meet on the first week of trial in just over 2 weeks' time, I think it is. Thank you very much for your help.
Thank you.
Thank you. Oh, can I ask you to liaise with the court officer to make sure the order reflects what we've been discussing.
Thank you, Your
Not
Honour.
not necessarily each of you personally, but members of your team.
Yes, we'll make sure that happens.
Thank you very much.
Great.
Okay, see you in 2 weeks' time. Thank you.
Thank you very much.